2022.
And next monthly list will come in 5th May only.
Lordship, some upgradation if your Lordship could.
Okay, monthly list, then you let it appear in the monthly list. '87. Direction was given to appear today.
A matter was not followed.
87 to 90. Okay, let's see. এটা যদি না ওঠে করবে ঠিক আছে
Not agreeing, sir. That is very right.
No, 87 to 90.
Certainly.
Oh. Oh. 29. Oh, most probably anyone mentioned this matter, that this matter, I don't know. This matter will appear along with WPA 21117 of 21. Most probably when this matter was moved, metro matter. Oh, yesterday one person mentioned. Yes. It will appear. It will appear, I don't know. Let my SEO come. Okay, he will ascertain and then. Yes, call the list.
Item number 1 has come up at 9 students. Kindly sees the previous order made by a coordinator. This is
Yes.
relating to a tender floated for construction of way bridges. Now, the immediate urgency is, I am definitely, there is an interim protection restraining them from floating further tenders. What we are on is, there were 2 occasions where we figured the lowest. But despite everything, the authorities, for undisclosed reason, have chosen to cancel the tender. First tender cancelled. Second tender also we participate and we come as the successful bidder. The quoted rate, insofar as we are concerned, is much lower. The government is likely to generate more revenue because commission is on the basis of commission. We have promised, or rather our rate has is in such a manner so as to ensure that the government generates more revenue. Be that as it may, for undisclosed reason, once again, one line rejection. Rejection in the sense, not my rejection. Tender cancelled. Now, the other honorable judge felt that you participate in the fresh tender. We are first and foremost questioning these cancellations. First cancellation I have not put to challenge. The second cancellation. Now, what I was humbly beseeching your lordship, since Mr. Roy, who is representing the respondent, is not there, I'm instructing Mr. Chatterjee to put him on notice. Let the matter appear tomorrow under the same position, so that the effective decision is made. Because, if your lordship ultimately is with me, then the cancellation would be set aside and I am likely to be awarded the contract. In the event your lordship is not with me, then, the consequence is a fresh tender. Now, this is the sum and substance of the matter. There are only one line decisions. No effective, the entire file needs to be produced according to my humble understanding. Because, why they thought to cancel is recorded in some undisclosed paper. It is not disclosed in the affidavit. It is not disclosed in the affidavit. I mean, this is the sum and substance. If your lordship wants, I can show your lordship papers.
So you give notice, oh, yes, Mr. Rai has come.
My lord, this matter has come without notice, my lord.
No, and hence it is to be mentioned. Don't say, and so that both of you can agree.
Be rest assured
both
that I
of-
did not want to do the matter without you.
No, that's true, that's true.
So that both of you can agree to a date. On that date, the matter.
Kindly
will be
fix up a
taken.
date, my lord.
Tell
If
both
it
of you.
comments to your lordship tomorrow, if it comments to
No. Next week. Next week.
Okay, Monday.
Monday, call tarik.
may it be on Wednesday.
Wednesday, yes.
6th, 7th.
On Monday is monthly list.
7th.
Yes, Wednesday, yes.
Seventh.
Wednesday.
7th at the top.
Okay, yeah, have the learned advocate appearing for the respective parties, leaves the matter for
Lord,
further
12 PM
consideration.
তুমি তো আসো
On
12টার
seventh.
সময় তো
এটা একটু ওপরের দিকে রিচ করে
Appearing for the stateless form.
রিচ করে yes
Lord, I am for the respondent number 5, my lord.
why under the
headmaster.
heading to be mentioned yes
my affidavit in opposition, my lord.
This is my affidavit in opposition.
Affidavits are complete, my lord.
No,
Huh?
I have not received any reply.
where is your reply
I too don't have the reply.
The reply was served upon us.
Reply, my lord, we are not relying, my lord.
My lord,
Reply, we are not. Because, my lord, very simple issue, my lord.
so you are for the school authority
my lord, I am for the headmaster, respondent number 5.
headmaster yes why only headmaster has been made party and you are আচ্ছা আপনি ওইখানটা
Pool was not made party, my lord.
হ্যাঁ মিস্টার নন্দী আপনি ওইখানটা শুধু লিখে রেখেছেন
My lord, this is-
এফিডেভিট বসো
cancelled, was rejected, my lord.
okay
On the ground, my lord, that my lord, lordship will kindly take page 31. In connection with the subject noted above, your prayer for employment on compassionate ground is summarily rejected on the basis of following grounds. According to GO number such and such, you are not entitled to get employment on
page 31
page 31.
page 30 yes
Now, my lord, my prayer was rejected. Now, my lord,
Class 8 pass certificate could not be authenticated by the competent authority.
my lord, may I, my
Well,
lord.
there are two
My lord,
class
there-
8 plus
my lord,
certificate
there are-
issued by the
my
same
lord,
headmaster
in
of
the-
the same madrasa.
May I complete,
Yes,
my lord?
Oh,
Please, sir. In the opposition, my lord, the state has shown, my lord, there are two certificates. One is, my lord, my date of birth is 1978, and another one of 1988. I have given only my lord 1978 certificate. Now, my lord, after my lord, they inquired from the school, my lord, possibly my lord, due to certain my lord clerical mistake, my lord, that certificate has gone. Which my lord, the headmaster has also my lord clarified in his opposition, my lord. That my lord, there was a clerical mistake. My date of birth is 1978. And my lord, the headmaster has also, my lord, kindly see page 31. The headmaster, after the rejection of this my application, my lord, headmaster has also clarified before the DI that my lord,
Page.
page 31. So with due respect, I am to inform that Ramjan Ali Sheikh, son of late Bashir Ali Sheikh, was reading in class 2 in the year 1992 and passed the annual exam. His date of birth recorded in the admission register of the school is 2/6/1970. No other documents like student register, progress report register are found as they are either lost or damaged. Now, my lord, this is the situation. School has also clarified, my lord, that I was studying and I studied at that school. I passed class 8. Now, my lord, I understand, my lord, there is two certificate before the DI which was sent by the school. It is not by me. In my application, my lord, there was only 1978 certificate. Now, my lord, only solely on that ground, my lord, because there were other avenues to verify whether I have class 8 passed class 8 or not.
Now, where is that Geo? 9 July 2009.
My lord, it says, my lord, that for appointment of group C, my lord, group D staff, we have to plus class 8, my lord.
Class 8 pass.
Class 8 pass is required, but that we are not.
Have you annexed that Geo?
That geo is not, we have not annexed.
It is with you.
No, my lord.
Oh,
Geo is not there. But my lord, it says, my lord, only for class 8 for group D, my lord, class 8, my lord, pass would be the eligibility criteria. Now, my lord, after the clarification by the headmaster, my lord, there is possibly no scope scope to doubt, my lord, that 1980 certificate was a type.
so you reconsider.
One thing, my lord. Kindly come to my affidavit, my lord.
Yes.
That page 12, my lord, answer R2. After getting the two certificates, my lord, the additional district research school was directed to conduct an inquiry. And that inquiry result is, my lord, next page 13.
Yes.
I am reading, my lord.
Yes.
With reference to the above, I would like to submit following information in respect of HON'BLE Ali Sheikh, Ramjan Ali Sheikh, son of such and such, only basis of the admission register of the school. The school authorities cannot show any other documents, that is attendance register, result book, counterfoil of the transfer certificate for verification of the above certificate. So the undersigned is unable to verify the class 8 first certificate of Ramjan Ali Sheikh. Excepting the one document, my lord, there is no other document lying in the school authority, my lord.
That they have also clarified in page 31 of my writ petition also that is anything other than it's not available, either lost or
How
damaged.
is possible, my lord? Excepting one document, there is no other document in the school. If your lordship direct us to consider, we shall definitely do that. There is the situation, my lord.
So, if there is
So suspicions
Yes, my lord.
has arisen since you have no other document, only admission register. So it is a proof. It is a matter of proof, and it has been proved that you got admitted. Thereafter, whether you continued or not.
thereafter, my lord, the certificate issued by the school, my lord, that I have passed classes, that is, my lord, the
There
testament.
must
That is testament, my lord. My lord, there, my lord, after my application, my lord, what the school did, my lord, that they gave, my lord, another of 88 by typographical. For that, why should I be made? I be suffer, my lord. Because, my lord, after I made the application to the concert authority, they asked documents from the school. Now there was a typographical error from the end of the school.
Not typographical. Now question is
there was an error. There was an error on part of the school to send the document. Now,
Plus,
further, why should I be made
Same
suffer?
headmaster within a
Because
month.
my lord, admission register is there, my lord. The certificate of the register headmaster is there. I passed in 1970, which I provided with my application, my lord.
Would you be able to produce any mark sheet of class
No,
6,
nothing.
7, 8?
No, nothing.
You have passed, you are,
After 1980, it would be, my lord, difficult, my lord.
your own mark sheet,
My lord, difficult. You ask me, but-
your educational qualification is class 8 pass. So you should have preserved it. You show the mark sheet of class 8 pass,
my lord,
class 8.
my lord,
Annual examination, you show the mark sheet of annual examination class 8.
my lord.
Moreover, my lord, the father of
My
the
lord,
petitioner,
I question to myself, my- if my lord situation, my lord, I have lost it, my lord.
Hmm?
Now, if situation, my lord, I have lost it, my lord. Supposing, my lord. Now, my lord, if the school issues a certificate that I passed class 8 in the year 1978, my lord. My lord, because sorry, my date of birth is 1970. So, my lord, that would be, my lord, sufficient, my lord.
Not only 70, they have now questioned as to whether you have really continued your study. You got admitted in the school, it is admitted position. That you took admission in the school, but whether thereafter you continue study and you passed class 8 or not, that is a matter of question. You remove such suspicion and get the order and get the job.
My lord, such suspicion is removed from the certificate itself. That is my humble.
Certificate, the person concerned who has certified this, he must have some material.
My lord, because, my lord, the
So how from you are getting?
one
my
was
lord, he was a
My lord,
You show any document from your school, that he appeared in class 8 examination and he passed the class 8 examination, annual examination of class 8. So otherwise, how you can certify this thing?
my lord, this I have admitted that all the documents have been damaged. So I cannot provide over here.
Okay, if damage following any incident, natural calamity or any other incident, theft or anything like that, man-made incident, to show any diary or anything like that, contemporaneous any diary or anything that you brought this fact to the knowledge of our authority, any authority.
Then if my lord gives
In
permission,
this way, no, you are now justifying the issuance of your certificate. You show that this person continued his study and he appeared in class 8 examination, class 7 examination, and this is his mark sheet, or the mark has been recorded in our register from any document, any document.
if my lord,
Because of the fact, now this suspicion has arisen in the mind of the authority concerned. Whether judiciary can say that no, you shut your eyes and accept the certificate.
if my lord gives permits time, so I can take some instruction from my client and
What instruction? What has come epidemic?
my lord, this is the
Unless I
instruction.
can give you, so the burden is upon you to prove. Okay, mere certificate when they are saying that except your name, only your name was included in admission register, thereafter in no document, not a single document, they have find that your name is appearing. You are unable to show that at any point of time you appear either in class 6 examination, class 7 examination, class 8 examination.
Because, my lord, nothing else should be produced, my lord.
Huh?
Because, my lord, in connection with other students also, my lord, because it is a general register, my lord. Because, my lord, what, my lord, at page 13 it says, my lord, that school could not produce. Because school does.
And hence I quote consciously taking note of this fact that school are now taking this plea that no documents have been preserved by the school. The school has no document.
That also reflects.
Now your document,
that-
you produce,
That also reflects on page 13 of the, my lord, their affidavit, my lord.
or a disputed question of fact.
বলা হয়েছে যে স্কুল কিছু শো করতে পারেনি
So a disputed question of fact file suit.
We shall measure endeavor, my lord, if something could be found. My lord, kindly
Huh?
kindly allow the week's time, my lord, we shall.
Court will not enter into that question of fact whether you at all appear, you continue to study, at all appear in any examination, class 5, class 6, class 7, class 8. So any single document.
We shall endeavor, my lord. Because, my lord, the entire dispute, my lord, arose, my lord, due to, my lord, the fault of the school. Because in sending, my lord, document, where, my lord, they say, my lord, my date of birth is 1988. Because my application was in order. Now, my lord, I am suffering for, my lord, the mistake on part of the school. Because school has not preserved anything. Now, I made an application that enclosing this
You are the custodian of your own testimonial. Every testimonial is issued to the person concerned. Your Madhyamik certificate, Madhyamik mark sheet, admit, all are issued to you.
kindly allow us a week's time, my lord, we shall.
So it is your responsibility to preserve the same. It is your own testimonials. To prove that yes, I am a 8 pass candidate. So,
Kindly allow us a week's time, we shall enter.
no, what can be done? You go to the civil court.
Kindly allow us a week's time, my lord. If it fell from your lordship, my lord, that we should, my lord, at least produce if certificate, if the mark sheet or something is available, my lord, kindly allow us a week's time, we shall make an endeavor, my lord.
And ছোট করে লিখে লিখে আছে the writ petition pertains to claim করেছিল first candidate, 8 pass candidate, বা class 8 pass candidate. 88, 10 বছর সেইখান থেকে ইয়েস
Lordship, I am for the state lordship.
হ্যাঁ
I am for the petitioner.
Last day I have made my submission, Lordship, for orders.
হ্যাঁ yes.
I have given my affidavit in opposition.
Give me reminder.
Kindly, my lord. Your lordship kindly see page 35,
Oh,
34. 30, I joined as assistant teacher in 1985.
Oh.
34, your lordship kindly see. Thereafter, I joined as assistant headmaster 15 May 2006. After joining as assistant headmaster, my pay was refixed, page 34. Your lordship kindly see page 34. Just my lord, the shortcut I got it.
yes,
The facts.
yes, yes.
Page 34, this was the fixation approved by the additional district inspector of schools within his jurisdiction. That is the fixation. That is not the disputed before your lordship. That is, my lord, your lordship will subject pay fixation as assistant headmaster. Page 34. You got it, my lord, page 34.
Yes.
Pay fixation as assistant headmaster. Subject, approval of
Yes.
34. This is, my lord, my pay fixation after joining an assistant headmaster that was approved by the additional district inspector schools. Last two line, pay fixation with effect from 15 May 2006, when I joined as assistant headmaster. This is not disputed before us. Now the next page. I joined as headmaster 14 July 2006. No, I joined as headmaster 26 September 2008. That I approval I have. 26 September 2008. Now the district inspector of schools, North 24 Parganas, has approved my pay scale. Your lordship kindly see 35, not 36. Your lordship kindly is 36. Subject, fixation of pay, Dr. Manoj Kumar Patra, headmaster of Belgorия High School. What is the fixation? Third line, 11,850. With grade pay and additional grade pay, total 12,400 on 26 September 2008. You also got in third line. This was 26 September 2008. I joined as headmaster in Belgorия High School. This was approved by the DI. This was fixation as per ROPA 1998. That is why, my lord, the small amount 12,400. Now next page. Next page, this is the dispute comes.
Yes.
This is as per ROPA 2009. Same fixation has been revised 29,910 with effect from 26 September 2008. Your lordship can see page 37. Third line. This was revised under ROPA 2009. 29,910.
That would be 20,050 according to them.
I'm sorry. 29,910. This was fixed after giving me 2 additional increment. One increment already given as assistant headmaster, and one additional increment for taking higher responsibility in higher secondary section. That is the dispute before your lordship, whether I was at all entitled for another additional increment or not. DI has approved, so that was not my fault. DI has 29,910. This fixation was done. Next page, page 38. After so long, I enjoying higher scale of pay, page 38. ROPA 2019. Now my pay fixation was done. District Inspector of Schools has approved, page 38, you also can see,
Hmm.
1,07,500.
Hmm.
As on 1st July 1st January 2020. This is the financial benefit of ROPA 2019, 1st January 2019, serial number 11, page 38 at the bottom.
Hmm.
1,07,500.
Hmm.
So that is not the disputed till my revision of pay scale under ROPA 2019. Now, your Lordship, my Lord, I retired from service on 31st July 2023.
Hmm.
Pension papers has been forwarded. Page 45, your Lordship will find. This is the e-pension application, now the present procedure. That is the e-pension application was submitted. Your Lordship will find page, just my Lord, the shortcut, page 53. What was my basic pay I had drawn? 1 lakh, page 53. This is the, my Lord, the pension application was submitted.
Hmm.
Last page, at the last line, 1,20,900. You also got it? 1st July 2020.
Page 52.
Page 53.
53, yes.
At the end,
Yes, yes, yes.
64.
Hmm.
1st July 2023, 1,20,900.
Hmm.
1st July 2023, I retired 31st July 2020. This is my last basic. You will also kindly see, objection was raised by the Joint Director.
Hmm.
Page 56.
Page 56.
Objection was raised. Middle portion, pay in service book and in part D to be recasted as follows. 26 September 2008, 29,050 as headmaster. You also got it?
Page 56.
Page 56, middle portion block. Within block, my Lord, that is the Joint Director of Accounts.
Yes, pay in service book and
In
part D
to be recasted as follows. 26 September 2008, 29,050. 26 September 2008, when I joined as headmaster. That is page 37. Once, my Lord, just my Lord, the revert page 37. Page 37, DI has approved 29,910. Page 37. 29,910.
Yes.
DI has approved, sanctioned my pay scale with additional increment. Joint Director say no. You will not get the additional increment. When? 26 September 2008, when I joined as headmaster for taking higher responsibility for higher secondary section. Now, my Lord, this decision now raised in regard. My Lord, the entire issue has been settled by the Honorable Division Bench, and you will also kindly see page 60. This is under challenge. That has been recast by the District Inspector of Schools.
60.
29,910. That has been rectified. 29,050. As per the objection of the Joint Director of Accounts. Now the pension has been refixed. I had to deposit the, my Lord, the amount of overdrawn paid in excess because of wrong fixation. And my Lord, the ultimately pension payment order has been issued. Your Lordship will find page 72. My Lord, the fifth line, last pay. 1,17,400. I drawn 1,20,900, page 53. Page 53, my Lord, the you also will find my e-pension application.
Yes.
That is the reduced my basic pay and calculated the overdrawn. My Lord, the last occasion, my Lord, I submitted a compilation before your Lord. That the in place of that compilation, my Lord, kindly accept this. I have prepared, my Lord, the appraise. My Lord,
Will you take back it?
this is the, my Lord, from ROPA 2009 till the decisions, my Lord, the observations. Just, my Lord,
Yes. Where is the 3%?
yes, that is the ITLs. Just, my Lord, you'll also kindly see first page. This is the ROPA 2009.
2009, yes.
There is a clause, paragraph 11. paragraph 11, page 8.
Yes.
In case of promotion,
Hmm.
I promoted to a assistant headmaster to headmaster. From one grade pay to another in the revised pay structure, you will see paragraph 11, pay structure on and from 1st January 2006, because the ROPA 2009 with retrospective effect. Fixation of pay of an employee shall be made in the following manner. One increment equal to 3% of the sum of the pay in the pay band and the existing grade pay shall be computed and rounded up to the next multiple of 10. This is the 3%. This is not the clearly stated that how the 3% increment will be added. Subsequent amendment has been given by the School Education Department, page 12.
Yes.
Page 12, this is comes, my lord, the memorandum dated 8 October.
Hmm.
I am relying, my lord, the paragraph,
2.
page 14, paragraph 4, additional increment, page 13 at the bottom.
Hmm.
Page 13 at the bottom. Additional responsibility,
Yes,
additional grade pay.
Yes.
Tell us to skip over page 14.
Hmm.
The middle portion, additional increment
Yes.
for appointment to the post of headmaster or headmistress or assistant headmaster or assistant headmistress, as was being allowed in the unrevised scale of pay, is discontinued from the date of coming into force of the revised pay structure, provided that those who already got additional increment before 1/1/2006 in the unrevised pay scale for his appointment to the post of headmaster, headmistress, or assistant headmaster or assistant headmistress will get their pay fixed in the revised pay structure with effect from the date of option by taking into account the additional increment already allowed to them. So this additional increment has been discontinued from 1/1/2006, ROPA coming into force. Now this is the 1/1/2006. This is the discrimination. One set of headmaster will get paired to 1/1/2006. One set of headmaster after one. Now the School Education Department clarified that. That is page 16. No, that is page 20. No, 20, no?
Yes.
That is no. Before that, page 16, 16.
Yes.
30 ACD, 10 February 2010.
Hmm.
You will also kindly see
Hmm.
paragraph 9.
Hmm.
Para 9, page 18. How pay, you will also kindly see page 18.
Yes.
Para 9. How pay will be fixed in the revised pay structure in the following cases. School was a high school, 5 to 10, before 1/1/2006. Left hand side.
Hmm. Para 8.
Para 9.
9. Oh.
How pay will be fixed in the revised pay structure in the following cases. A school was a high school, 5 to 10, before 1/1/2006. But it was upgraded to higher secondary school between 1/1/2006 to 27 February 2009. 27 February 2009, ROPA was issued, memorandum date, effect from Act 2006. Now the right hand side. Headmaster of a high school was not entitled to any additional increment other than the scale of pay, the post in unrevised scale. If the school was upgraded to HS, higher secondary school, within the period of 1/1/2006 to 27 February 2009, headmaster would be entitled to additional increments from the date of such upgradation as per provisions of the unrevised scale of pay. This is also discriminatory because this period will get after 27 February 2009, nobody will get. Now, your lordship, this has been clarified, page 20.
Yes.
This was the also School Education Department, last two paragraphs. In the instant case, the headmaster was enjoying headmaster scale of pay which has been revised on the date of his option to come under ROPA 2009, and after upgradation of the school, he became entitled for benefit of a headmaster of a higher secondary school under ROPA 2009. Hence, there was no necessity to explain the case further for those cases where upgradation was made after 27 February 2009. Allowed after 27 February. Last paragraph. Headmaster, headmistress of the high school who has been appointed as headmaster in an upgraded higher secondary after 27 February 2009 will be entitled to get 3% increment and additional grade pay in pursuance of the ROPA 2009 clause 11 and 8 October 2000. Just now I have placed. So thereafter cut-off date was lifted. Now everybody, all headmasters. Now this was also settled by the Honorable Division Bench. Now the government, page 21, issued a circular by the Joint Secretary withdrawing the circular, page 20. This is the Joint Secretary. Well, no. Hence, I am directed to inform you that, page 21. No additional increment can be allowed as per ROPA 2009. Accordingly, memo dated 4th February 2004, page 20, stand withdrawn. Because of this withdrawal letter, all fixation has been recasted from the date of joining as headmaster by the DI of school. Even DI has approved my pay scale as headmaster. Now this GO has been set aside by this honorable, by the division bench, also by the single bench. Division bench, page 23. This is the honorable division bench judgment. Only I am showing page 26, 2 paragraphs. So in that judgment, my lord, their lordships held that since the 2017 GO has not been challenged, so my lord, with discussion that the Joint Secretary has allowed once that cannot be withdrawn. However, the liberty was given to them to challenge that, and they challenged that. My lord, the lordship will find 2 writ petitions, page 23, Satyajit Ghosh and Ashish Kumar Mai. They have challenged by subsequently by writ petition, page 30, 30, and another. I am not showing my lord the entire judgment, page 30 and 35. Satyajit Ghosh and Ashish Kumar Maiti. After the division bench judgment, they filed a writ petition and writ petition was allowed. Now the one judgment just now I am showing, that is page 40.
Yes.
40, that next operative part 48. 48. In view of the above observation, this court directs for setting aside of the impugn notification dated 22nd March 2017, issued by the Joint Secretary. So, well, that has been set aside and allowed the writ petitions. This regarding 3% additional increment to the headmaster of higher secondary school for taking higher responsibility. Now, my case, my lord, at the time they have not retired at the time of filing the writ petition. My case, petitioner retired from service. At the time of retirement, his fixation was refixed by the DI of schools, exactly covered by the another division bench judgment, page 90, relying Rafiq Mosi and considering the ROPA 2009, 3% additional increment, everything has been considered by the division bench judgment, page 90. The division bench held that no refund. Even I refunded the amount by consent with treasury challan. That has been discussed by the Honorable Justice Mousumi Bhattacharya, page 100. Exactly, my lord, covered by.
Yes.
First paragraph, the petitioner's claims refund of an alleged overdrawn amount, 77,718, which was deposited by the petitioner through treasury challan under what the petitioner claims to be compelling circumstances. Entire judgment relying the
Judgment to দেবে
তুমি দিয়েছি তো না দিইনি? ওইটা দিয়ে দাও
judgment to দাওনি
তো লাগানো আছে। And my lord, all my lord, 2014 GO government order, 2017 everything after discussing, and ROPA 2009 thereafter amendment on 8 October 2009. Her ladyship has been pleased to direct the authority to refund and to refix the pensionary benefit upon granting 3% additional increment from the date of joining.
Right.
Only this is my case, my lord. I have two prayers. My lord, the second prayer, my lord, to refund the amount which I have deposited under compulsion, together with interest. So that has been settled by the honorable. This is also her ladyship also they pay to with interest. And first prayer, my lord, to refix my pensionary benefit on the basis of the fixation approved by the DI, that is page 37. They have recasted my pay scale from 26 September 2008 onwards from the date of joining as headmaster. That country. This is my lord the
This matter are instructors long back now.
Oh,
2018 surfacing matter, my lord. They are with the DRT, two DRT file, both are disposed.
the petitioner is unrepented. Stop. Mr. Ghoshal, learned advocate, repenting the respondent bank submit that with the passage of time, the writ petition has become infectious. Stop. Having heard the submission, having heard, just stop having heard. Heard Mr. Ghoshal and Peru.
My lord, on behalf of the petitioner, I am praying for not this week. She is ill, my lord. She is not coming to court.
Okay, not this week.
I am appearing for the state, your
Not
lordship.
this week.
Okay, not this week.
Great.
For the petitioner. My lord, the petition has been filed by the petitioner. my
I'm
lord,
for the respondent bank.
on the ground that he is the highest bidder. He paid the entire amount in respect of one commercial shop room, my lord. During pendency of this writ application, my lord, the shop room has been handed over to, the possession has been given to the petitioner. Therefore, my lord, nothing remains to decide in this application, my lord, and petitioner does not.
Chami, you have to know that the learned advocate repented. You are Mr. Das. Mr. Das, learned advocate repenting the petitioner submit that petitioner grievances raised in this petition has already been addressed. Stop. In
They are challenging the possession notice and
My lord, the
2017
petitioner
possession notice.
does
Yeah,
not
I-
want to proceed with the, because the dispute has already been settled between the parties.
settled. Acha. Here, learned advocate repenting the petitioner submits that dispute raised dispute involving this petition as the
They paid one.
same. Now same বলতে eight who is appearing.
I have give notice between.
আচ্ছা ওই petition is unrepented, Mr. Ghoshal submits. ঠিক আছে। In view of the above, we no further interference is called for. Great. Submits ওই কথাটা বলে দিন যাতে issue has already been settled. Issue raised in this petition has already been settled. Next.
And
May it please your lordship, my lord, I'm for the petition.
Lordship, learned counsel appearing for respondent back is a personal difficult. Lordship is out of Kolkata. Lordship, kindly bring for 2 weeks time, Lordship.
My lord, before your lordship grants that application, my lord, on the 22nd of April, when your lordship had called up the matter and appeared before your lordship, and your lordship had directed service upon the learned state advocate, and as well as issue a notice to the RBI as well as.
Oh, that matter, fixed deposit.
Yes,
Fixed
my lord.
deposit.
They have secured loan.
My lord, I have
We-
the
we have
affidavit of
submitted-
service, my lord.
We have filed a 184 under 137 of the Criminal Procedure Code, and my lord, only remedy lies before the Ombudsman, Reserve Bank of India.
My lord, however, little did I know that a tragedy, a grave tragedy has unfolded, my lord. When I informed my client after this hearing happened and I served the notices, I found out it was informed to me that the petitioner had actually committed suicide, my lord, on 10th of February
Sorry.
2024 while awaiting justice, my lord. And he hung himself, my lord. Now, what happened is, since he committed suicide, now his wife and son, being the legal heirs, are to be substituted, my lord. So I have preferred 2 applications, my lord, one for the condonation of delay and another for substitution of the legal heirs, my lord. And I will serve them a copy right now, my lord, of the said applications.
My lord, that application may be accepted.
As a learned advocate for the petitioner informs that
I had categorically shown to your lordship, my lord. Now, when the bank, the State Bank of India, are actually under the RBI, whatever the directives that the RBI gives, they're duty bound to follow that. And because of their lackadaisical approach towards customer security, this incident has happened, my lord, this whole saga. Despite
okay, okay, at the time of final hearing, this matter will be taken care of, dealt with. You give the application only.
my lord, the
Delay of
affidavit of
how
service.
many days?
Um,
It is affidavit of service.
my lord, about the earlier order, my lord, 22nd of April.
Okay, affidavit of service filed on behalf of the petitioner is taken on record. As a delay of how
Motion to file supplementary affidavit.
I appeal for the spot number 4 in this matter. The Axis Bank. This is number 4, yes.
Okay, based on the prayer made on behalf of the petitioner, the writ petition is adjourned, stand adjourned for a period of 1 week. Based on the petitioner change. Item number 11. None appears. No accommodation DD. None appears nor has any accommodation. None appears on behalf of the either of the parties nor accommodation has been sought for. Review thereof, dismissed for default. Next.
Well, also I appear on behalf of the petitioner. Well, in this matter, 11th March 2022, the writ application finally decided and dismissed. Thereafter, petitioner preferred an appeal. The appeal court, the set aside the order of the coordinated bench of this court.
And remand the matter.
And
Remand the matter back.
the reheard the writ petition and with affidavit in opposition.
When it has been dismissed.
It has been dismissed on
Dismissed for
11th
default.
dismissed not merit, decided on merit. That is 11th March 2020. Appeal court has
So application under the heading application. Why can one?
this is the recalling of the dismissal order which has been passed by the coordinate bench of this court. Merit has been decided. Thereafter, appeal court set aside the order of the coordinate bench of this court, single judge. And now this application has been filed for the recall of the order dated 11th March 2020, passed by the coordinate bench of this court. That is kindly come to the pay order dated 11th March 2020. That is, writ application has been dismissed finally.
রিকল কি করবে রিকল তো হয়েই গেল অ্যাপিল কোর্টের অর্ডারে রিকল হয়ে গেল না
And 9th September 2020 appeal court set aside the order of the 11th March 2020.
তাহলে ওর এটা চাইছে না
So why recalling is required?
It is already been recalled in the appeal court.
Appeal court cannot recall. Appeal court has set
Oh,
aside.
everything is set aside. Since it is set aside, my lord.
Appeal court has been set aside.
So your application for recalling is now infactuous.
The writ application be directed to heart.
My lord, in this matter, my lord, now, my lord, I am praying before your lordship. My lord, I shall file the affidavit in opposition.
There is a direction, my lord.
There is direction in the appeal courts also, but I have to file it. Kindly allow me some time, I shall file.
The
I
division bench already gave the direction.
Yes. Division bench, my lord, leave was granted to me, my lord, to file the affidavit in opposition, but I could not file. I pray before your lordship to file it. My lord, kindly fix a date by giving me 2 3
I am
weeks.
just adjourning the matter. I adjourn
Lordship.
the matter.
Yes,
I cannot extend
Yes,
this
yes.
time by the
my lord,
division bench.
my lord, I shall come with
It will be it would amount to modifying this
Lordship.
order.
lordship.
Huh?
Kindly, my lord, 3 weeks time be after 3 weeks, your lordship fix it. In the meantime, I shall prepare the opposition and I shall serve to him. If he files the reply, then it may be hard. ঠিক আছে?
They have to direct file the opposition. Thereafter, fixing the date. No, restore করা যাবে না বলছেন উনি।
No, it has not been, no
Rule.
application has been filed according to me as far based on their submission. I have not gone through the entire record. That no application for recalling is required to be filed. This court, a coordinate bench of this court, by passing an order on 11th March 2020, dismissed the writ petition. An appeal was prepared. The appeal court set aside that order and remanded the matter back to the single bench. And direction was given upon the respondent to file affidavit.
Yes.
Okay, so they have filed the application for recalling. Recalling is not required, already set aside. Now I cannot extend the time
Lordship, I understood.
fixed by the Honorable Division Bench.
Lordship,
That will be amount to modifying their order.
yes,
I am just adjourn the matter 3 weeks,
Uh.
for 3 weeks. In the meantime, you exchange that.
Lordship, that will be,
Huh?
my lord.
Okay.
And added your lordship list, and added your lordship list to what hearing.
Lordship fix করবেন তো।
আচ্ছা, hard
এটা কত?
13 now, 12.
And item number
Oh.
39 for the IBPS, my lord, respondent.
You are for the petitioner.
My application for restoration.
Oh. When it was dismissed?
But,
On
it was dismissed.
20th, 30th September 2020.
My lord, we have not been served with a copy, my lord.
Hey, Sam.
But, served তো আমাকে affidavit করতে হবে। তারপরে?
Okay, give a copy to him and come tomorrow.
I have been, my lord,
Okay, yeah.
it is already,
According to you, it was served.
yes, it's already there in your lordship's record, the affidavit of service.
Okay, you serve a copy.
I'll do that, man. My lord, 30th September it was dismissed. 5th of October this application is filed within 5 days. So, my lord, if my learned friend is agreeable, my lord, this application could be disposed of today. I'm serving a copy to him right here and now.
There is no delay.
Within 4 days, actually.
Uttarbango Kshatriya Gramin Bank.
Yes. No, my lord, I am for the IBPS, my lord.
He's one of the respondents.
One of the respondent, my lord. That is respondent number 5, my lord.
Oh, well, yeah.
Lord, I will not stand in the way in that case.
আচ্ছা, ঠিক আছে, আপনি নিন, আচ্ছা।
In lordship, I appear for the defendant opposite party. The matter arises out of the order dated 31st of January 2025, where the petitioner have challenged the time limit for granting further time written statement.
Yes.
My lord had thoroughly recorded the facts on the last occasion. My lord, the law is very clear. Order 8, Rule 1, my lord, it's not mandatory but directory. But what it also says, my lord, court while extending, they have to show, my lord, the reasons why they could not file within the prescribed period of time, and court has to be satisfied on that. Nothing recorded.
Lordship kindly takes the order sheet once. Lord, in the order sheet, kindly takes that on 5th of March 2024, the suit has been filed, and thereafter on 8th of July 2024, the fresh requisites has been filed for issuance of summon upon the defendants. Thereafter on 7th of October 2024, the postal receipts had been filed and the defendant appeared by filing a wakalatnama. Thereafter on 31st of January 2025, we filed one petition directing them to serve the copies of the documents in support of the plan. That was altogether allowed by the learned court, and till today they have not yet served copies of the documents in support of the plan. Although they assured before the learned court that they will serve on that date, but till today it has not yet been served.
Now, my lord, kindly takes up the order number 2. Order number 4, 7th October 2024.
Page. Oh,
certified
it has not been pagitated.
The certified copy cannot be. 7th October, the plaintiff files Hajira, postal receipts, and track report. The defendant number 2 appeared and filing Vokalatnama, files one Firisti, and prays for time to file the WS. Therefore, on that day they appeared, they knew, Milord, what are the documents with them, what other documents they don't have. They ought to have filed this application on that date itself. Why after 1 year? Almost not 1 year. November, December, January. Why after 3 months? Even, Milord, on 33rd December also date was fixed.
Now, when you have filed that application, on 7th October, you have not filed any application.
7th October, we have filed one application inter alia stating that we want to
On 7th?
7th October 2024.
It is order does not reflect so.
We have just stated that we want to contest the suit by filing a written object
Yes.
statement.
Then when you have filed?
Then on 31st of January 2025.
7th October.
31st January, which is the subject matter of challenge, and kindly takes that order once. Now it states that plaintiff files Hajira, sole defendant appeared by filing Vokalatnama and filed one petition directing the plaintiff to serve the document for preparing the WS. Copy is duly served to the plaintiff, peruse the petition, heart considered. The prayer is allowed. Lord, till today no documents has been served. Lord, they assured before the learned
Order
court.
dated, you are reading order dated?
31st of January 2025, which
Order
is the
number
subject
6.
matter of challenge.
Oh, heart considered. So you apply
You can file on the next date.
this order has been
Apply what, Milord? I have to only documents relied upon on the plaint. Where is the Milord subject to correction? My lord has huge experience, my lord, much better than me in track. Where is
this order
being them? Those are annexed with the Milord injunction application.
Mr. Bhattacharya, this order has not been challenged.
Yes, I have challenged that.
31st January 2025.
That is the impugned order. I have challenged in this revisional application.
This is the subject matter of challenge. Lordship, there is no scope for injunction. They have not filed any injunction.
Exactly so. They have to take it on their own.
They have
Or
stated in
they have to take steps for discovery and inspection. Where is the question of serving? Where is the question of serving them? My lord, only because this is a suit for eviction on the eviction of licensee, then my lord, these dilatory tactics, nothing else.
There is no question of dilatory. Let them serve. We will find on the
There
next
is
day.
the provision
Lord,
to
we have-
serve. I will only rely upon the documents relied upon on the plaint.
They have filed it in the Firisti.
Firisti, my lord, at the time of my lord adducing evidence.
Hmm.
When my lord injunction, my lord application is filed in compliance with order 39 rule 3AB, my lord everything is served. My lord, there is no application.
Order 7, Rule 14.
That
Order 7, Rule
yes, that
14.
is documents relied upon with the plaint.
Whether with the plaint, the
Yes.
word with the plaint has
Yes.
been used, I have marked. It is my book. For you, I have marked. With the plaint. Order 7, Rule 14.
With the plaint.
He can seek direction under Order 7 Rule. If any plaint is not filed with any document sought to be relied upon by the plaintiff, the defendant shall have a right to get an order from the authority, from the court concerned upon them to furnish that document.
The court has not recorded that it has not been filed. Court has not recorded that. My plaint is defective, court does not record that.
So, or in that circumstances, order is without reason. Order is cryptic. I can remand the matter, you pass reason order. That days are gone.
No, definitely.
Now you have to file document along with
Yes,
it.
along with the plaint.
Only
But
that
where
practice,
provision
is
made for service.
what I say, that who are the old men, they are still doing this practice in the court, that
Those are annexed
we
with the,
shall not give the.
those are annexed with the injunction application. Plaint all are delivered there. But the plaint, my lord, and documents in original I have to serve with the defense. There is no such provision. In compliance with 39(3)AB, my lord is absolutely right. All documents have to be annexed and served. But with the plaint, my lord, no, that is not. Discovery inspection चाहिए.
And Order 14 Rule 1 says the parties and their pleaders shall produce on or before settlement of issues all the documentary evidence in original, where copies thereof have been filed along with the plaint
Exactly.
or written statement.
Exactly.
That means the
time of
legislature intended the document.
With chief.
I am showing that if in spite of being directed you fail to produce document, court can.
Defense will be struck off.
Yeah, defense written statement. Court can dismiss your suit also.
Order 14 Rule 1, kindly see. Only the list, nothing else.
Order 13. It is, I am saying order 13. Order 13 Rule 10 is the direction for production of evidence. Court may send for paper from his own order. 13. So, what can be done? So don't be adamant to and non steadfast or stuck to his decision that I shall not give the document. Now the situation has gone. And everywhere, writ petition, Supreme Court, High Court, everywhere. It is a basic tenets of natural justice. Against a person, you will use a document, but you have to serve the copy that I shall use this document against you. None has asked you to give the original. Keep it original, but he is entitled to get the copy. So don't you give within a period of 2 weeks, and he will file
Let's see within
within a 2 weeks thereafter.
No, 8th May is the date for filing written statement. I will give them by Monday, let them file written statement on 8th.
Okay. So the present divisional application has been prepared, challenging the legality and propriety of the order When suit was filed,
24.
Time frame.
any other suit.
Deciding officer is vacant.
Huh?
Deciding officer is vacant.
Actually, needless to observe
Endeavor,
that
we shall make endeavor.
needless to observe that the learned court below made an endeavor, sincere endeavor to dispose
Object
24.
transfer.
ট্রান্সফারটা অবজেক্ট করছি না কিন্তু স্টেট অবজেক্ট করছি
Stay হচ্ছে তো action
Huh?
hearing হবে. Stay
my
তো
lord
আমি
if
power.
it is
Well,
transferred there is no objection my lord
This
they
is
may be
section
transferred
24 of the Civil Procedure Code.
but
My
if
lord,
they ask for stay
My lord,
that is
only
opposed.
only one thing, my lord. Since they are not objecting, my lord, what happened, my lord? When I filed, my lord, a suit for declaration of my the title as on the basis that I have become, my lord, owner by way of adverse possession.
Oh,
My
My lord,
learned friend
my
had
lord,
also-
kindly see page 86, my lord.
my lord, I have, my lord, my learned friend has
There is
also
a
filed- sir,
direction.
আমি বলিনি। I have
না ওইটা
also
তোমরা
filed
সাপ্রেস করেছো
হ্যাঁ, ঠিক আছে। I have also filed my lord, they have filed a suit, my lord, for eviction. For eviction of a trespasser. Now, my lord, the suit, my lord, the eviction suit, my lord, was decreed. My suit for declaration was dismissed.
পেপার বুক হয়ে গেছে আমাদের ট্রান্সফার হলে 16 মেনশন করবো আমাদের পেপার বুক আমরা টাইম সার্ভিস করে দিয়ে
my lord, kindly see page 86. The running page 4 of the order, my lord. My lord, the third paragraph, in default of depositing the area within the time stipulated herein above, in the evidence, the default is committed in depositing 2 consecutive months. The order of stay shall stand vacated automatically and the defendant respondent shall be free to proceed with the execution case irrespective of fact that the appeal is pending before this court. My lord, and the appeal which my learned friend is trying to transfer to this honorable court, my lord, in this appeal also the stay application has been refused. For the, my lord,
Prayed for stay. I am praying for transfer.
my lord,
to you.
that has not been stated in their my lord petition. That has been suppressed.
My prayer is not for stay.
You have prayed for stay,
I have
In
not
the-
pressed it.
then that is okay.
রেকর্ডটা চলে এলে মেনশন করে দেবে ওরা এখনো পেপার বুক সার্ভিস করেনি আমাদের I have not prayed for stay.
My lord, kindly
your
record
lordship admitted, my lord, my revisional application. I did not pray for stay because I knew my client is unable to, my lord, pay occupation charge. Stay has already vacated by the order of the honorable division. That's why I did not pray for stay. I'm only praying for because unless it is not transferred, there will be conflicting of judicial decision.
My lord, they have proceeded with the appeal in the Alipur court, my lord.
No,
Even, my lord, there is a stay, my lord. That stay has been vacated by that order. After even they have filed this honorable court, they have not made the transfer before that. When there is a stay has
What
been
is his
vacated,
objection? He once says, my lord, he is not opposing transfer. I am not praying stay.
which the petitioner filed for challenging. Oh, the appeal arising from the decree of eviction is pending before this court.
Yes.
Our appeal
For
dismissal of suit for seeking declaration.
That is suit is valued at 100 rupees. My lord, I cannot come, my lord, in view of the.
No, I am thinking that the appeal will be withdrawn from this.
And will be hard analogously with the present first appeal FA
with
2430.
same number, or here it was
Here, my lord, department will give a number.
renumber.
Department will give it a number. The same thing, my lord, happened, my lord, in another matter, my lord.
Yes, I was seeking that order. last part. Last part.
Page 4 and 5.
Is withdrawn from the analogous hearing and disposal, yeah, along with a PAT pending before this court, which is superior than reference to. Both the suit was heard analogously.
Analogously.
Common judgment. Both the suit was given a common judgment, disposed of.
So you have no objection.
If they only paid for transfer, I have no objection. If they paid for stay, then I have
But I
objection.
am not.
Yes. The court is not applied his mind as to whether he will be entitled to get a stay or not.
And I'm not pressing it.
Yes.
My lord, kindly
Now-
record that.
Huh?
Kindly record that. They have not praised that.
Yes, they have vacated in terms of
This
the
application.
In this application.
In this application, I shall not entertain their such pair also.
It is only for transfer.
Any interim order is passed only for the purpose of disposal of the proceeding placed before the court.
My lord.
Or which is going interim in the court. ঠিক আছে? If any interim order is passed, that would be passed only for the purpose of disposal of this 24 petition. Okay. The present divisional application has been prepared under section 24 of the Code of
This is my application.
Yes.
Affidavit in opposition, may we file an affidavit in opposition?
Yes. Why two?
One against the state, another against the private respondent.
Oh, the affidavit exchanged by the parties are taken on record. Yes.
My lord will kindly take first, this is a tender matter. The allegations made in the writ petition are such that, my lord, the tendering authority or the employer has acted in breach of the terms and conditions and the procedure laid down in the tender itself. But this is not a case where, my lord, the petitioner seeks to challenge the terms and conditions of the tender. This is a case where, my lord, the petitioner seeks enforcement of the terms and conditions and the procedure laid in the tender, laid down in the tender. And my lord, the law is very well settled, my lord, in this regard. So kindly take, my lord, I take your lordship to the subject tender, which your lordship will find at page 26. Just giving your lordship a brief overview of the matter.
Page
26, my lord.
Yes.
This is the invitation to e-tender for patient diet, indoor patients at the ESI Hospital, Maniktola for 23-24 and 24-25. Well, this term is now extended because of, my lord, protracted litigation and series of litigation. But the term is now extended. Actually, the relevant tender is, the contract is valid till 2027, subject to correction by any of my learned friends.
Only thing, my lord, before my learned friend commences, my lord, the respondent number 6, my lord, is already working in the hospital, Maniktola ESI Hospital. They have been awarded the work order, my lord.
Respondent number 6 is working, still working.
Not still working. They have been awarded the work order.
Award is the subject matter of challenge. Affidavits have been exchanged.
Oh,
My lord, I believe, my lord, the case which is sought to be made out by my learned friend is that since the work order has been issued, since they are working, so nothing remains to be decided in the writ petition, subject to correction. My lord, there is a distinction between a supply contract like this and an infrastructure contract like, my lord, building of construction of highways, my lord, bridges, roads, etc. My lord, in an infrastructure contract, if the work order is issued and, my lord, a party commences work on the basis of the work order issued, my lord, and if the petitioner or the, my lord, the contesting party is unable to secure any interim order or something like that, then obviously, my lord, interference at a later stage during the course of hearing of the writ petition may or may not be warranted depending on the facts and circumstances of the case. But this is a supply contract. Well, the supply contract is unique in its own way because, my lord, they are supplying, the period is till 27. If I succeed in the writ petition and if I am able to convince your lordship that this is a fit case for interference by your lordships under Article 226 of the Constitution, the obvious consequence would be, my lord, reworking of the, my lord, this evaluation in terms of the conditions laid down in the tender, more particularly in this case, clause 39 thereof.
Yes.
This is not a dead issue. My lord, in my most respectful submission, this issue is alive and this issue is still germane for consideration. So, my lord, may I take your lordship directly to the tender document? Kindly take the tender document. Your lordship will find it at page 26. My lord, your lordship has taken the patient diet, indoor patient, this is for supply of patient diet, indoor patients at the ESI hospital, Maniktola, for the relevant years. Now it is valid till 2027 because of the litigations, as I pointed out. I take your lordship directly to the relevant clause. The clause which has been practically violated and or not adhered to by the employer or the tendering authority while awarding the contract. Kindly take page clause 39 at page 34.
Yes.
Mode of calculation of rates. 39.
Hmm.
The calculation of rates of acceptable bidders will be on the basis of overall monthly financial implication for supply of all categories of diets.
Hmm.
In case of the lots will be drawn under the supervision of the superintendent of the hospital with help of the tender selection committee. So, my lord, first of all, my lord, the tendering authority or the tender selection authority has to ascertain from the available records that what is the overall monthly financial implication for supply of all categories of diet, taking the empirical data maybe for last 1 quarter, maybe for last 6 months, maybe for last 1 financial year, or maybe for even 1 month, or in some kind of average. So,
Apart from that empirical data,
the data will be available. Suppose, this is Maniktola ESI.
Oh.
Contract is awarded for Maniktola ESI. So, before the contract is awarded, already some contractor is supplying these food articles, this cooked diet, to the ESI hospitals. Now, then they will get the data for each and every day. Suppose, there are, I tell you, lordship, this is so interesting. There are patients who are admitted. What are the meals available? Essentially, morning tea, breakfast, lunch, evening tea, dinner. Your lordship will find that in some cases, the patients are generally admitted, say for example, after breakfast, at around 12 noon, and some patients are also admitted in the night. When the patients are admitted, there is a specific diet, namely admission diet, which is general for all. Then, the categories of the patients are identified as to what kind of diet would suit a particular patient. Suppose, I am a diabetic, or somebody has some cardiovascular problem. So, for diabetic, it will be a diabetic diet. For a cardiovascular patient, it will be a cardiovascular diet. For a normal patient, who doesn't have these kind of complications, would have a normal diet. So on and so forth. When I come to the categories of diet, there are at least 7 or 8 categories of diet, 6 or 7 categories of diet, 8 categories of diet. I stand corrected. Now, the question which would arise is that, the inflow and outflow of patients in a day. If we take the inflow and outflow of patients in a day, your lordship will find this is a variable data. And this variable data can only be collected from the existing sources. Namely, this supply which is being made for, say, for example, last month, that is immediately before the issuance of the ENIT, that's the electronic e-tender, or maybe last quarter, or maybe last 6 months, if we take the half-yearly financials, or maybe for one fiscal, that is one financial year. And these variable data, when collected and mean average is worked out, it will give an overall consumption, overall financial implication figure. Now, my lord, what your lordship will kindly now take on 13th November 2023, which your lordship will find at page 312. Because there were a series of litigations, my lord, I will point it out for one reason or the other.
Yes, 312.
But this was prior to any litigation. This was at the stage when the tender was floated and the petitioner as an intending participant in the tender process, pointed out that please adhere to this clause 39 of the tender notice. That means please ascertain the overall fiscal financial implication. My lord, this is the letter your lordship will find. Kindly take last line of the first paragraph. My lord has got that.
I would like
I
to
would
refer.
like to refer to clause 39 of the tender terms and condition, which is as follows. Mode of calculation of rates. My lord, again, this is quoted, which I have read out to your lordship, but just for the sake of my lord, my own
Yes, yes,
satisfaction, may I read it out just once more. The calculation of rates of acceptable bidders will be on the basis of overall monthly financial implication for supply of all categories of diet. So, my lord, this is there. It is pertinent to note that the rate provided in the bill of quantity by the individual bidder is incomplete as it is consolidated rate. The determination of this rate should be based on the rates quoted in diet schedules 1 to 8, which the bidders are required to fill in accordance with the tender terms and conditions. Now, my lord, this goes on. My lord, this was my representation. Then what happened, my lord? On 12th of May, 2024, I make a further representation, which your lordship will find at page 43.
43.
Yes, madam. Again, my lord, I'm sorry, my lord, I should have waited.
Yes, yes.
I'm so sorry.
Same, almost same.
Your lordship will find it at the last paragraph of page 43. My lord has got that?
Yes.
Please adhere, please refer to clause, again I quote this clause 39, and again I reiterate my stand that please adhere to this condition or to this procedure. Now, my lord, now kindly take the next relevant date, which will be 22nd of May 2024. This is my writ petition, the first round.
Yes.
Well, this is a judgment rendered by my lord Mr. Justice Shobhashachi Bhattacharya. Now, my lord, kindly take only paragraph 9. I have given the page, my lord. I'm sorry. 316. I'm sorry, my lord. 316 to 318. I'm sorry, man.
Yes.
Kindly take paragraph 9 of this order or judgment. That is, your lordship will find it at page 318.
Yes.
It is expected that the tender issuing authorities shall comply with not only clause 39. I'm sorry, my lord, your lordship has got that?
Yes, yes.
Clause 39 of the tender document, but also other relevant terms of tender as well as the governing financial rules while taking a final decision in the tender process. So, my lord, this was the direction. Then, my lord, this petition was disposed of, and my lord, then the tender issuing authority was directed to take a final call in the matter, resume the process. 320, your lordship will find that if ultimately on 24th of May, subsequent to the direction issued by this honorable court in the order dated 22nd of May 2024, the tender issuing authority resume the process. My lord has got that. That is the corrigendum at page 320. Then, my lord, kindly take, my lord, your lordship will find the writ petition number is also referred to, and the order of this honorable court is also referred to. Then 321, your lordship will find the tender committee informed that the selection of the L1 bidder or the lowest bidder would be held on 28/5. This email was sent on 27/5/2024. May I just read out this?
Yes, yes.
This is to inform you that the selection of L1 bidder, as there has been a tie, this is where, my lord, the trouble starts. As there has been a tie, a tender so and so for supply of cooked diet for indoor patients at ESI hospital authorities, Maniktola, will be held tomorrow, dated 28/5/2024 at 2 p.m. at the chamber of MPO cum superintendent. You are also requested to bring original government ID and so and so. So, my lord, the tender issuing authority says that there is a tie of the quoted rates. Well, how they derive at the tie? Well, I put the question to myself. I take your lordship back to the tender document. Kindly take, my lord, for once, page 35. Because this is the only case which has been made out in the affidavit of the state respondents. But interestingly enough, this is a case where I find though the state respondents are not present at this point of time, but I find that they are present to the private respondent. Why I tell your lordship, the affidavit of the state respondent and the affidavit of the private respondent are somewhat verbatim similar. And I will point out those paragraphs. They are like, my lord, inseparable twins, not lost in the fair, my lord, as we used to old Hindi movies, they're not lost in the fair. They are those inseparable twins whose affidavits are like this, my lord. Paragraph 4. In fact, my lord, the decision.
Comrade Sen, senior advocate, Ali and Amritlal Chatterjee.
My lord, we mentioned this matter upon notice, right? We mentioned this matter upon notice. Well, it's not that we didn't mention.
Okay, yeah. So it would be
State should
presumed
appear.
that it does not want to
State is
participate.
required to appear, madam.
Huh?
The state is required to appear. We are the private respondents, madam. We are working. And lordship will kindly consider another point of maintainability, whether he's at all, he has the locus to maintain this writ application or not, madam.
That
It
I
is
will
not
answer that.
maintainable at all.
Whether he has the locus to maintain this application or not. That we will put forward, madam.
Subject to
whenever
correction,
chance will
subject to
come.
correction by my learned friend. The locus of the petitioner, perhaps subject to correction, I stand corrected, has not been taken in the affidavit. Subject to correction. If it has been taken in the,
This petition.
even at the time of admission of the writ
He
petition,
was not awarded the work order. At
That
the
doesn't-
relevant point of time, my lord, it was his brother who was working. And thereafter, my lord, pursuant to the direction of this court, my lord, the work order was awarded in favor of the private respondent. That was much later, my lord, pursuant to the direction of this court. In the meantime, there were series of litigations, appeals, counter appeals, my lord. I'm not going into that, but pursuant to the order of this court, my lord, the award was given in favor of the private respondent. But before that, my lord, his brother was the existing contractor. So, lordship, we shall put forward our submissions, my lord, whenever our chance, we will be getting our chance.
well, we have got an overview of their submission. So may I just continue?
Yes,
Shall I
submitted.
continue, my lord?
Lordship,
He has submitted that there is a difference between infrastructure contract
And the supply
and supply contract. And he is claiming that issue is not dead issue till it is alive.
then if your lordship, I'm praying for an indulgence in that view of the matter. If your lordship will kindly fix it on next Tuesday, since Monday is a monthly list day, my lord. If your lordship will kindly fix it on Tuesday, that is কত তারিখ?
বুঝতে হবে দাদা ভিড় দেখি
Whichever date suits your lordship before vacation.
Before vacation, lordship.
Before vacation,
একটা
whichever
ফাঁকা দিয়ে দিন
maybe next week after, but before vacation. Subject to your lordship.
কোনটা 6 তারিখ অনেক 7 তারিখ
And my lord, your lordship will make it clear that we will serve once more upon the.
yes.
But my lord, if they don't appear, my lord, we may be allowed to proceed on that.
আচ্ছা yes আচ্ছা হার সবাইকে নাম
But my lord, one twin will get the other twin next year.
Yes.
17, your lordship fixed it at 2 p.m. today.
Yes.
Now, my lord, I have received an affidavit in opposition today.
Oh,
Therefore, my
yes,
lord, I was
I'm
only.
sorry, Mala, my junior has handed me over the copy.
file
If
for
I
it,
can, if I can, Mala, file it now, Mala, in court. I have given them a copy, but then it is belated.
so you filed the কোনটা টাকা হবে?
17.
number?
16, Mala, will take some time.
16 will take some time.
Okay.
17,
Okay,
Mala,
RP number
Our
17.
matter, my lord, 16 hour matter, 2 p.m.
Okay, that matter.
Yes, my lord.
that matter, Mala, will take.
কোথায় গেল? Okay, so you place it.
May I find it?
Affidavit in opposition filed on behalf of the at 2 p.m.
At
I'm
2
getting 7 2 p.m. Yes.
Lordship, grateful.
চুপ করে বসেন তো, এত
থেকে বড় ছোট দেখাচ্ছি চল
Yes.
My lord, this is, my lord, today, my lord, I want to start, my lord. দাদা একটু নিয়ে রাখুন। My lord, my learned friend, my lord, has completed his argument, my lord. My learned friend petitioner has completed his argument, my lord. And my lord, today, my lord, I want to.
দিন এটা দিবেন রেকর্ডটা দিন 16 এর রেকর্ডটা দিন Yes.
My lord, it is the procedural. It is a procedural matter, my lord, that petitioner must, my lord, within the purview of this office, my lord, writ petition. That is the statement of the writ petition. He has not any right to ask anything over and outside this act, my lord. That is the pleadings of the writ petition. He has not any right to say anything about in another things, my lord. Now, my lord, I am coming. If your lordship will come, my lord, writ petition. That is, my lord, paragraph 1 is, that is the plot number. I may not want, that is, he prays for 935, 936, 937, and 970.
Yes.
And now, my lord, if your lordship will come, paragraph 3, my lord.
Yes.
That is, on 13th May 2002, in connection with the aforesaid proceeding, a notification bearing number 24, North 24 Parganas, that is LAP 4/7 ASO NTP, 24th April 2002, under section 4 of the Land Acquisition Act, at present repeal
was published whereby and whereunder it was notified that the said land, including a vast area of the land which Raigachi is likely to be needed for the purpose of Rajarat New Township project. In the said notification, it was mentioned that the said respondent has also invoked the provisions of section 17 of the Land Acquisition Act at present seal, and the notification was published in Calcutta Gazette on 13th May, my lord, that is 13th May 2002, my lord. That fourth notification was issued, my lord, that is fourth notification was issued on, my lord, 13th May 2002, my lord. Now, my lord, para 4, my lord. That subsequently a further notification bearing on 24th, that is NTP, on 5th June 2002, my lord, that is under section 6 of the Land Acquisition Act. That is the declaration. That is, my lord, that must be noted, my lord, that is 19 June 2002. Yes. There is within time, my lord, there is no any. Now, my lord, that on about 12th August 2002, petitioner was served a notice under section 3 and 4 of section 9 of the Land Acquisition Act 1994, at present issued by the collector being the respondent number 2 herein, whereby and whereunnder the petitioner was asked to appear before the said respondent number 23rd August 2002 to state the petition and nature of interest and claim of compensation in respect of the said land, to lodge objection or anything else. That is, my lord, knowledge is 2002. And all the things, my lord, all the statement, my lord, that is in, yes, all the statement 1, 2, 3, 4 are, my lord, 2 to my knowledge. That is 5 is also 2 to my knowledge. That is knowledge, my lord, that is 2002. Now, my lord, if your lordship will come, and paragraph 12, my lord, that is the page 8, that is the release also, that is 3466 and 3467, that is also 2000. All the, my lord, things is happened in 2002, my lord. Now, 14th, my lord, paragraph 14, on 17th December 2015, once again the petitioner had been to the office of the collector being the respondent of a hearing, and requested the said respondent to issue formal order of de-requisition to avoid any sort of complication to enable the petitioner to develop the said land according to his choice, my lord. From 2, my lord, he is camped about 2015. There is no other, there is no manual explanation in these paragraphs from 2002. And now, my lord, if your lordship will come to prayer, what is his prayer? A writ of mandamus commanding the respondent to issue a formal order of de-requisition in respect of the said land, enabling the petitioner to use the said land of her choice forthwith.
Acquisition, not requisition.
What is that?
The requisition is something.
Yes, my lord, the acquisition. My lord, আরে বাবা আরে বাবা ওখানে তো 3 হয়নি তাহলে requisition না 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 ঠিক আছে. That is the commanding the respondent to issue the formal order of de-acquisition in respect of the said land, enabling the petitioner to use the said land to her choice forthwith. Therefore, that is the subsidiary, my lord, calling upon the respondent to produce under cost directing the respondent formal order of de-acquisition. That is only, my lord, his prayer is de-acquisition, nothing else. Now, my lord, in in this, my lord, I filed one affidavit in opposition, my lord. I am coming with that. That is page 2, my lord. Paragraph 3, Roman 1, that for the public purpose of Rajarat New Township project in Mauja number Ato, the land acquisition proceeding was initiated according to number of under land acquisition by invoking section 17(4) of the said act, involving subject plot number Ato, that is his plot, my lord, in full along with other plots of the said Raigachi, and involving RS record plot number 3466 and 3467, notification under section 4 of the Act of 1894 for the land acquisition proceeding was issued, and the subject land of the writ petition was involved in the said notification published in Kolkata Gazette, my lord, that is 13th May 2002. That is, my lord, the 4 and issued on 13th May 2002, my lord. And Roman 2, my lord, the declaration under section 6 of the Act, my lord, proceeding was issued on, my lord, 5th June 2002.
Your affidavit?
Yes, my lord.
Okay.
Your lordship.
Affidavit in opposition.
Affidavit in opposition, respondent number 2, 3, and 4.
Respondent 4A.
4A, no, my lord. 4A, my lord, my learned friend.
I have got.
I am for 2, 3, and 4.
Got it. Yes, you read out your paragraph.
Paragraph 3, page 2, my lord, paragraph 3, Roman 1.
Yes.
That is the notification initiated under Land Acquisition Act. Section Ato District Land Acquisition Proceeding was initiated by Ato by invoking section 17(4) of the Act, involving subject plot number in full along with other plots of the said Mauja Raigachi by notification, and also notification under section 4 of the Act, that is 13th May 2002, my lord. And 6, my lord, that is 5th June, that is Roman 2, my lord. The declaration under section 6 of the Act is Roman 2, my lord, that is was issued LA number Ato and Ato on 5th June 2002. That is declaration, my lord. And, my lord, the notices for verification of title were issued under section 9(3)(a), 3(4), but the title could not be verified of the writ petitioner as a result of the relevant plot remained non-verified. Accordingly, award was declared as not verified, and the award amount has been deposited in court learned LA by judge number Ato on 16th May 2006, my lord. Now, my lord, in this matter, my lord, now it has been found, my lord, according to me, my lord, award was declared, my lord, your lordship can note it, that 17th February 2023.
Yes.
And possession was taken on the 21st February 2023. That is very, very relevant, my lord. Now, my lord, it has been found from the award details, RS plot number Ato and Ato, that is 4, my lord, Roman 4.
Yes.
Roman 4, my lord, it has been found from the award details, that is plot number Ato, that is his plot, my lord, that apportioned award was declared in the name of Ramdulari Joyshwal, that is the present petitioner, with not verified status. For RS plot number Ato and Ato of Mauja Ato award Gopalpur has been declared against many persons as per apportionment. For RS plot number 3467 of the said Mauja, the award includes the name of the writ petitioner Ramdulari Joyshwal with not verified. My lord, they come after verification if it is found, but as she was not present in the before the officer, for that reason, my lord, not verified award is. Possession of the acquired plot, that is Roman 5, as in the notification under section 4 and under section 6 of the Land Acquisition Act, which includes the subject plot as above said, was handed over the requiring body, that is the representative of the Planning Division Housing Directorate, Government of West Bengal on 21st February 2003. My lord, possession is also, my lord, your lordship can note that 21st February 2003, the possession was handed over to the requiring body. My lord.
Yes.
Now 6, my lord, Roman 6, that it is very clear that the land acquisition proceeding, which was initiated by number Ato involving the subject plot, has been concluded and completed following due provisions of law as laid down in the Land Acquisition Act 1 of 1894, and the land acquisition proceeding has been completed in a legally permissible stipulated time-bound manner, and it is completed more than 10 years before the lifespan of Act of 1894, when it was repealed in the year 2014, that notices for verification of title were issued under section 9(3) and 3(b), 9(3) and 9(4) of LA Act, but the title could not be verified in the writ petitioner. As a result, relevant plot remained not verified. Accordingly, award was declared as not verified, and the award amount was deposited to the learned LA judge. According to the provision of my lord, we have deposited the money to the LA judge. If he wants, he can take the and proceeding which has been completed more than a decade ago, that is page 6, my lord, for which award has been declared and possession of the acquired land has been handed over to the requiring body. There is no such provision of de-requisition or de-acquisition. Moreover, in the writ petition, facts of the facts were described in a distorted and misleading way, as has been repeated meaning of the fact that the Land Acquisition Act of Ato repeal on Ato, but this has nothing to do with the land acquisition proceeding of 4(7) of the NTP, because this is proceeding has been completed within 2006 by filing a writ petition. It is a settled principle of law, duly diligent efforts are to be requirement for a party seeking to use the adjudicatory mechanism to attain an anticipated relief, and it is evident in the instant case the petitioner never acted with due diligence for the last 10 years, and it is clear it neglected practices and waste of valuable time of the Honorable Court. That it was held in the Supreme Court of India, a portion, another settled canon of the administration of justice, no litigant could be permitted to misuse the judicial process for filing frivolous petition, and no litigant has right to. This is the, my lord, my affidavit in opposition, my lord. Now, my lord, page 11, Annexure 1.
Yes.
That is the 17 and 4, my lord. That is 13th May, my lord. That is the first I mentioned. Whereas to the governor, that land is likely to be needed to be taken by government at the public expense for a public purpose, that is for Rajarat New Township project in the Moujaz, Raigachi and Gopalpur, jurisdiction list number 12 and 2 respectively, PS Rajarat, District 24 Pargana, it is hereby notified that for the above purpose, a piece of land comprising a divisional settlement plot as detailed below and measuring more or less 4.681 hectares, that is bounded as specified below, is likely to be needed within the aforesaid Moujaz, Raigachi and Gopalpur. This notification is made under the provision of section 4 of Act 1, 1894 to all whom it concerns. A plan of the land may be inspected in the office of the collector, North Chobishwar Barasat. In exercise of power conferred by the aforesaid action, the governor is pleased to authorize the offices for the time being engaged in the undertaking with their servants and workmen to enter upon and survey the land, and to all acts required and permitted by this section. In exercise of the powers conferred under subsection 4 of section 17 of the Land Acquisition Act 1894 Act 1 of 1894. The governor is pleased to direct the provision of section 5A of the act shall apply.
Not apply, yes.
Shall not apply of the land as described in the schedule below, which in the opinion of the government, provision of the section 17 of the act are applicable. And now, my lord, 6. That is after that, my lord, whereas the governor is satisfied that the needed public purpose, not being the purpose of union, namely the Rajarat township project in the Raigachi and Gopalpur, Raigachi and Sobhana declared that a piece of land for revisional settlement of Atho and Atho bounded as specified below is needed for the aforesaid Atho. Declaration made under the provision of Act 6 of the Act 1 of 92 Halda. That is 4 and 6 was done, my lord. Now, my learned friend, my lord wanted to one question that 17.4 was there, but 17.3, according to 3A, my lord, there is a provision to give the, before taking the possession, but at the time of taking the possession, that is 80% should be given on. I say, I submit before your lordship, that is not a mandatory. When mandatory? If 17, my lord, if your lordship will see, when mandatory provision is there, if mandatory is there, my lord, there is a provision that there should be, if that is done, if not done, then that will happen. That is 11A. If your lordship will come 11A, the provision of 11A of the Act. For a moment, my lord, if your lordship come for 11A.
দেখুন তো বই আছে কিনা
11A of Act 1.
Act 1 Land Acquisition Act 1
আমার আছে,
এটা আমারটা দিন
my lord
দিচ্ছেন 11 এটা বার করে দেব
হ্যাঁ 11 এটা
ওকে
11 এটা
হ্যাঁ
দাও
that is section 17
no my lord now my lord your lordship will see first 11A.
Yes.
My lord, if your lordship will come, 11A, the collector shall make an award under section 11 within a period of 2 years from the date of the publication of the declaration, and if no award is made within that period, the entire proceeding for the acquisition of the land shall lapse. That is a mandatory provision. Mandate given to the legislature, to everybody, that if you have done, you have not done, then that will be lapsed. That is a mandatory provision. Now, my lord, if your lordship could come 17, 3A.
3A, yes.
Yes, my lord, 17, 3A. Now, my lord.
Here also shall.
I am not coming for shall, my lord. There is a provision of mandatory provision that will be lapsed.
Yes.
Now come, my lord, in 3A.
Shall with a default clause.
And
it would be treated as a mandatory nature.
Now, my lord, if your lordship come 3A of 17.
Yes.
Before taking possession of any land under subsection 1 or subsection 2, the collector shall, without prejudice to the provision of subsection 3. That is, I may not want to take time for 17.1, 72, and 73. My lord, that my learned friend, my lord, on that previous occasion, my lord, tender payment of 80% term of the compensation for such land as estimated by him to the person interested entitled thereto. Pay it to them unless prevented by some one or more of the contingencies mentioned in section 11 and of the section 2. And where the collector is so prevented, the provision of section 31, subsection 2, except the second provision, shall apply as they apply to the payment of compensation under that section. Where is the provision? That is a mandatory. If he fails to do so, then your case will be lapsed. Or otherwise, you have nothing to say, my lord. For that reason, my lord, that is not a mandatory provision. That is a provision that you must pay some money of 80%. For that, if I may not, my lord, pay that amount of 80%, my case will not be, my lord, go to the dustbin. That is the intention of the legislature. My lord, you must come with the intention of the legislature. We have nothing to say except what legislature wants to do. In this, my lord, in this case, my lord, 3A, there is legislature never said that this is our view. Our view is that you pay some money of 80%. But if not paid, that is not your case will be lapsed or anything else. That is not a mandatory provision, my lord. My lord, judgment is also there, my lord. That is not a mandatory provision. That is the provision of otherwise, my lord. That is, you must pay that. If you have, you can pay. But if not paid, that is not your, my lord. Your entire proceeding, you will be lapsed, my lord. Now, my lord, my landed friend, my lord, showed one, my lord, as per my landed friend prayed, and as per the honorable other coordinate bench, my lord, direct us to show, to come with all the briefs, my lord, entire brief, my lord, and showed to my landed friend, my lord. I have given that inspection, my landed friend, my lord, took the inspection and take one. He said that those will be required, my lord. If you, my lord,
Order sheet.
Yes, my lord. I filed one order sheet.
Order sheet, yes, he wanted to say that you have not taken approval from the appropriate government.
My lord, I am coming. I know, my lord, what is that? My lord, from first page, my lord.
First page, yes.
That is notice. I may not. That is as per special LA, my lord. That is the second page, my lord. I may not want to disturb. Now, my lord, third page, 7/5/2002, my lord. Draft notification.
Yes.
Yes, physical of the said notice is brought. Now, my lord, next page. Next page, according to the provision, my lord, we must, my lord, circulate our notice to the, my lord, that is Asian page and Monoshakti and other gadget to the, according to the provision, that provision is there. If you want to forward, if you issued, you must, my lord, disclose, ventilated it before the newspaper, daily newspaper.
Published in the newspaper.
Yes, that was done, my lord.
4-1.
Yes, my lord. That was done, my lord.
Yes.
At page 6. Now, my lord, 7. That is a draft declaration. That is the 6, my lord. That is draft declaration has been approved. That is also approved, my lord. Now, my lord,
it should be approved.
Said draft declaration has been approved by the collector. That is a
draft declaration may kindly be approved.
Has been approved. The page 7, my lord. Next page, your lordship. Next page, my lord, paging Korane Budai.
Yes, page 7.
7. First line.
Order dated 12th June 2002. Draft publication has been approved. Yes.
Now the declaration.
Now the declaration.
Now, my lord, declaration.
Published.
Now, my lord, that is not the problem. That is how we may not want to. Procedure, my lord, next page, page 8, procedural draft is that. Now, my lord, page 10 is very
vital.
Yes, my lord.
Yes.
That is, my lord, your lordship will see the date 7th February 2003.
Yes.
Schedule verification done by Sri HON'BLE Bose, Assistant Land Acquisition Officer. Accordingly, award has been in term 12, 13, 13A, including award note is placed here, which may be kindly be approved. Now, my lord, that is by additional LA 0 Ato. Award in form 12 and 13, my lord, may be approved and signed by Special Land Acquisition Officer. Now, my lord, next page. On 17/2, ADMLR. Now, District Magistrate, North Chobbish Pargona, Joint Secretary ex officio to the Government of West Bengal. That is, my lord, 17/2. On the date of 17/2, that was approved.
award has been declared.
Yes, my lord. For that is, my lord, I placed before your lordship that award date is 17th February 2023.
Yes.
Now, my lord, that point has award has been declared on next page, my lord. That is very vital. That is award has been declared. That is, my lord. Now, my lord, I am coming, my lord, and payment made, position of the debtor to be handed over to the housing board. Payment made. Now, my lord, I am coming page 15. My lord, what point? That is the point of section 13.
Yes.
Post award verification made by the HON'BLE Bose as an LO. Statement showing the reflection of the postal and verification is enclosed. That is, my lord, 7803. That is also vital. My lord, your lordship, kindly note it. That page, my lord, my learned friend showed before your lordship at the time of his argument,
yes.
my lord.
Yes.
That is 7th August 2003. Now, my lord, come to section 13. There is a provision of only within 6 months. If any correction or anything else be done, my lord, that is 13A.
Yes.
Correction of clerical errors. The collector may at any time, but not later than 6 months from the date of the award, or where he has been required under section 18 to make a reference to the court before the making of such reference by order, correct any clerical or arithmetical mistake in the award or errors arising therein either of his own motion or the publication of the person presented by the local authority, provided that no correction which is likely to affect prejudicially any person shall be made unless such person has been by making a necessary. That is a 6 month. That is first award, my lord. If your lordship will see, first award,
17 February.
and now
2003.
that is 7th August.
7th
That is within 6 months. There is no any. So, my lord, from the affidavit in opposition and from the my lord official records, which is shown before your lordship, that, my lord, there is no any ambiguity or anything else. But my learned friend, my lord, wanted to show your lordship that there is some discrepancy. I submit before your lordship, there is not any discrepancy. And my lord, your lordship knows very well when the position was taken, and my lord, the vesting is completed, and my lord, all the other parties are take the money, but as he is not on that day before the authority, my lord officers, my lord, he is not verified. For that, my lord, according to the provision, that money was deposited to the LA collector, LA judge, my lord, and LA judge will, if he wants, my lord, he will take the money from the LA judge. There is no any, only he must file an application before the authority, and my lord, he will take some time, my lord. And 17.4, my lord, তুমি কি বলবে 17.4? তুমি ওগুলো বলবে ল পয়েন্ট গুলো না আমি বলবো কিছু?
বলো না। He's my senior, let him say.
No, no. না না না।
Okay.
Lordship, actually, Lordship, I place one judgment, Lordship.
Okay.
Judgment. I place these things. Even I will place that judgment because one book is there.
এই দেখি তোমার বইটা দাও।
কোনটা বলো?
My lord কে তো একটা বই দিতে হবে।
আমি এই বইটাই দিয়ে দেবো।
দেখি এক
Okay.
মিনিট।
No. Yeah. I shall take it out from my laptop. Don't worry.
My lord, your lordship contain 2028 SCC
2020.
হ্যাঁ ইনডোর ডেভেলপমেন্ট সেটাই বলছি।
Column 8 SCC indoor development.
Yes, my lord.
2020, volume 8, in the development of Lordship, covered Lordship, 494 judgment regarding acquisition, section 5A, 11, 17, all points, Lordship, elaborately discussed, Lordship. And relying this judgment, our High Court, Lordship,
single bench Justice Subrata Roy, passed an oral lordship of the judgment which was upheld by division bench. At the same time, went to the Supreme Court also stamped. Upheld. I think lordship thereafter lordship need not look at the time. But I felt
No, say Paul.
lordship.
My lord, if your lordship, paragraph 138.
138.
Yes, my lord. Please note this. 138 টাই বলে দিই আবার অত কি আছে। My lord, 138 last part, my lord.
Yes, read it.
The provision of subsection 4 of section 52 of somewhat similar to section 17 of the Land Acquisition Act 138, my lord. Just as, my lord, I am not going into the all the provision now has been taken and now government not withdraw from acquisition under section 48 and the provision of section 11A were not attracted. Therefore, the acquisition proceeding would not fail to be period prescribed therein. It was further held that, well, that is very important. It was further held that non-compliance with section 73A regarding part payment or compensation before taking possession would also not render the possession illegal and entitle the government to withdraw from acquisition. The aforesaid principle has been reiterated by the court in Chinnamai Atho, by the award Atho. In view of the aforesaid ratio, it follows that the provision of section 11A are not attracted in the present case, and even if it is assumed that the award has been passed within the stipulated period, the acquisition of land does not come to an end. That is the Indo-development. 48. That is what I submit before your lordship, that is not a mandatory. For that reason, my lord, that my lord, now my lord, that is the 17.4, my lord. What I am coming, my lord, 17.4 from the 11A, or my lord, where the mandatory provision is there, but 17.4, my lord, there 17.3A, there is any mandatory provision. So that point, and my lord, in indoor, that point was also, my lord,
Taken into.
yes, my lord. Now, my lord, my learned friend taken another thing, my lord, that is he is in position.
Yes, yes.
Yes, my lord. Now, my lord, if your lordship will come. My lord, 148 of Indo-development.
140 para of page.
No, page no, my lord, that is paragraph. Paragraph 148. In similar view has been taken by the market.
One minute, I am taking it from
148, my lord.
you just starting words. The court is of opinion.
Yes, my lord, a similar view has been taken in market committee and Kishan.
Yes, yes. Yes, got it.
Now, third line, fourth line, my lord, if your lordship will see, once vesting takes place and is with possession, after which a person who remains in possession is only a trespasser, not in rightful possession, and vesting contemplates absolute title possession in the state. My lord, that should be the provision. As because, my lord, when vesting order is there, we took the position, though so nobody can claim. And my lord, in the body of there are so many that it is not possible for the state to overlook, my lord, always in that land, my lord, we must take so vast land, it is not possible for the state to see whether any person is there or not. So, my lord, once vested, when taking possession of the land, nobody, particular the owner, has not any right to say, I am in the possession, I am in possession, as because he is a trespasser, not an encroacher. If he encroacher, we must, my lord, take the other procedure. If he trespasser, for that reason there is no any provision. Go and police will oust him at any point of time if he wants that I am in possession. That is the provision of law, my lord. Now, my lord, আর কি point নিয়েছে? আর তো নাইনি। My lord, now, my lord, my learned friend will say otherwise, my lord.
Now,
My-
he has,
Yes, my lord, if your
Yes.
lordship wants to say,
He-
ask me anything.
he has stressed on certain words used in the note sheet. Maybe post verification, post award verification,
My lord, that is,
estimate.
my lord,
maybe
I am, my lord,
approved.
I am
That is-
clarified, your lordship.
that it has already been approved by the
Yes, my lord.
appropriate government. Yes,
So I have, my lord,
stating that the award has been declared.
yes, my lord, and everything is completed, my lord. I have shown you the judgment and other things, my lord. And this is, my lord, is only, my lord, my learned friend asked for producing of the original record, which is goes in favor of us. I am not in that ABTBT in opposition. I am not with this type of auto. And for that reason, my lord, I am very glad that my learned friend wants to see the
Note sheet.
yes, my lord, note sheet and other things,
Aye.
my lord. So, my lord, I perhaps I hope, my lord, that I can
You have been
satisfy
able
your
to
lordship.
present your that
about-
case on behalf of the state
Yes, my lord.
successfully.
Yes, my lord.
Yes, anything in reply?
No, my lord, তুমি কিছু বলবে?
Oh,
না ঠিক আছে না তুমি বসো আই এম গেটিং স্ট্রেংথ তুমি থাকলে
yes.
ফার্স্ট অফ অল লর্ডশিপস after 14 years from the date of acquisition they filed the writ application and the latches and delay has not been explained anywhere. Even if assuming delay explained, that will not cure the entire things or any part of the things that the land acquisition is bad. Why, Lordships? Number one, Lordships, land statutorily vested to the state. Vested to the state and handed over the possession to the state, and thereafter he has no authority to raise any legality of the acquisition. Of the legality of the acquisition.
Yes.
Over the self-same matter, Lordship, our High Court, Lordship, the judgment was placed before your Lordship on the coordinate bench, Bholanath Kole versus State of West Bengal. Unreported judgment.
Yes, got it.
Yes, Lordship. Got it, Lordship.
Yes.
I am placing only one paragraph, Lordship. I think there is enough for page 13 of the judgment.
Page?
Page 13 of the judgment.
Bholanath Kole, division bench.
No, division bench, Justice Bosak, that single bench judgment was affirmed by the division bench judgment presided by Justice Bosak. And single bench judgment, I am placing single bench judgment pronounced Honorable Justice Saugato Bhattacharya in the year 2022. I have given the copy of the judgment to my learned friend.
Hey, yes, এই দেখুন তো ভোলানাথ স্কুলের কোনো সিঙ্গেল বেঞ্চের জাজমেন্ট আছে কিনা, নেই।
Lordship, I'm placing this, Lordship kindly.
Whether it was reported or
Yes, I'm for it.
reported? Bholanath Kole was reported?
No, Lordship, unreported.
Oh,
Lordship, one copy, Lordship, I'm giving it, Lordships.
okay, it is division bench, Bholanath Kole division bench.
Yes, Lordship, that judgment was affirmed by the
Affirmed by the division bench,
This-
but single bench আপনি পেলে ইয়ে করবেন।
and went to the Supreme Court. Supreme Court also
Affirmed
upheld
the-
the judgment of the Calcutta High Court, single bench and division bench.
Okay.
So it reaches finality. Oh, the
Different case number.
Yes,
Case number is different. How?
maybe
you can say that this
different
has been-
different case, principle of law with regard to
Opposition has been settled.
Opposition differs from the
no,
Yes,
not,
you want
not at all,
to say,
not at
you
all.
wanted to argue.
It is established, Lordship, it is established that the judgment is an authority on which it decides
Decides.
what not to. This is, in the present case, the act of invoking 17(4) of the said Act of 1894 on the ground of urgency has not been questioned, has not been questioned by the writ petitioner when the same was instituted such and such.
Yes.
On the affirming says such and such, next Lordship, faint attempt has been made in the question. In the meanwhile, entire process of acquisition stood completed on the taking the possession of the land in the year 2001, and in view of this thing, Lordship, such and such. With regard to this, it has been placed on the judgment of the Honorable Apex Court, 1996, Chamili Singh versus such and such. Lordship, I think, Lordship, Lordship, it may be placed before you. Otherwise, Lordship, it does.
No, I have got it. I have got it.
Yes, yes.
Yes, single bench judgment I have got.
Yes.
Reliance has been-
In this regard, page 13. In this regard, reliance has been placed on the judgment of the Honorable Apex Court reported in 1996 to SCC, page 549, Chamili Singh versus and others versus State of UP and other. Paragraph 4 to 15, the principle has been enunciated in the said judgment on the context of the invocation of 17(4) in the urgency thereby dispensing with the requirement of section 5A to the context that the urgency formed by the approved government to take the immediate possession is a subjective satisfaction based on the material before it. And it is entitled to great weight unless it is vitiated by malafide or culpable exercise of power. It is further held, it must be remembered that the satisfaction of 17(4) is a subjective one,
yes.
and so long there is a material which government could form such and such. Since making such award and handing over the possession of 17 to 27 July 2021, the present deed petition was filed on 17 January 2011. There is a delay ground, Lordship, I am coming. And the question has been raised by Mr. Banerjee while advancing the argument on behalf of the petitioner that on the ground of urgency, 17(4) ought not to have been invoked by the respondent authority, denying the right of the petitioner, making the deliberation of section 5A. This court finds it's opt to rely upon the judgment of the Honorable Apex Court, reported 1975, 4 SCC 285 Aflantun versus the Governor of Delhi. Lordship, it is the famous case of the Delhi Airport Authority. Assuming for a moment that the public purpose was not sufficiently specified in the notification and did not make a grievance of the such and such, if the appellant had really been prejudiced by the non-specification of the public purpose which the plot they have interested or needed, they should have been take steps, have notification on question on the ground within the reasonable time. They did not move the matter even after declaration under section 6 was published in the year 1996. They approached the court with the writ petition only in year 1970, when the notice under section 9 were issued to them. In the concluding portion of the judgment, the Munshi Singh versus Union of India, it was observed the matter of this nature, we should have been taking due notice of laches on the part of the appellant while granting the above relief. But we are not satisfied so far as the present appellant are not concerned. They have not been guilty of laches, delay, or consequence such and such. Not to think that petitioners writ petition to be allowed on the plea of such and such. Next, Lordship, I am placing page 15. Page 15, Lordship. In view of the aforesaid decision of the Honorable Apex Court, Upland Tune and others, this court finds there is no need to dilate the further on the ground of challenge in the present writ petition, since the petitioner filed the writ petition long after completion of the process of the acquisition under relevant provision of the Act in 1894. Such challenge of the writ petition has become stillborn due to passage of time, Lordship. Hard word have been used by the Apex Court. Accordingly, the writ petition does not merit the consideration and stand dismissed. However, there shall be no other cause, such and such. This judgment, our court judgment, Lordship, Justice Bhattacharya's past pronounced this judgment, was challenged before the division bench. Division bench affirmed this judgment, went to the Supreme Court. Supreme Court also affirmed this judgment. So, Lordship, my humble submission before Lordship, this is the best judgment. This is the best judgment in India till today with regard to the Indo Development Authority. Where Lordship, till today, because I am placing this thing. So I need not to say. I read out the paragraph only.
Only, yes.
While I am saying the best judgment with regard to land acquisition, 444 number of cases, leading cases have been relied. Yes, 441 leading cases were relied in this judgment. I can place this book, Lordships. I can place this book for your kind consideration, Lordship. My phone number is there, no problem, Lordship. I can take back the book later on. In the meantime, Lordship, I am placing the relevant paragraph. It boita din na. আমি বলবো
Yes.
Indo development এনেছে না নেই
Lordship, paragraph 136, 137, 138, 139, 140, 141, 142. Lordship, 142 is very vital, Lordship. 142 is very vital.
এটা জোসেফকে দিন না একটু
Next, Lordship, paragraph 147. Next, Lordship, paragraph 340, 340, 344, 343. Lordship, very, very important, Lordship, with regard to this. 346, 347, 348, 349, 350, 351, 353, 354, 355, 56, and last 5 line of 359. So I'm reading out this portion. Last 5 line of 359.
Yes.
In our view, page 391. According to him, Lordship, acquisition not valid. So, section Act of 13 will be invoked here in this case.
Yes.
In our last 391, in our considered opinion, section 24 is applicable to the pending cases proceeding. It is not pending, it is closed chapter, not to the concluded proceeding. The legality of the concluded proceeding cannot be questioned. Such challenge does not lie within the ambit of the deemed lapse of section 24, lapse of section 24 such and such. So, Lord, my response to submission before Lordship, the land was acquired, all legalities, formalities have been invoked. He is raising certain cracks, that has been done, that has been done, such and such, such and such, after 12 years or 14 years. Now, so it is held by the apex court or other different high court. No, you cannot raise this issue. You can raise this issue at the time of acquisition, not after this, number one. Number two, other landowners took the entire amount of money. You are the only sole person. You are residing there. You have not taken, in spite of section 9 notice, you have not taken the award money. It's your responsibility. 9.3 notice, it is his annexure. It is his annexure, Lordship, 9.3 notice. So, after completion of the acquisition, there is no scope to raise all such points. Okay. There is no scope. And Lordship, it was held, Lordship, our High Court held on self-same question over the land of Newtown, Rajarhat, Justice Sogato Bhattacharya's judgment, affirmed by Justice Bosak and Supreme Court. Same area land, Lordship, same thing, Lordship. Okay. After there you are. So my writ application is not at all maintainable. It's liable to be dismissed, Lordship.
Yes. I'd like to reply the argument advanced by the requiring body. Now, if I understand correctly, he has submitted before your Lordship that I have challenged the acquisition proceeding. In my whole writ petition, I have not challenged the acquisition proceeding. What I have said the fate of the acquisition proceeding. What is the fate? And my learned friend has said, relying on in the development, that notice was served upon the awardees. So if I don't accept the payment, so that is my fault. Possibly, my lord, if I am not wrong to say so, that I was not served with any notice in my writ petition categorically said that not served with any notice either under section 31 or under section 12(2) of the Act of 1894. Possibly requiring body cannot say as to whether I was served with a notice or not. This is the state who can say this, and state has not said that I was served with a notice under section.
Lordship, subject to its correction. I told only served under section 9 notice.
You have also said that no
and that
notice
is
of payment. You have relied on
that
it.
is the action.
You have
Whatever may be the thing.
You have placed a paragraph of the indoor development in support of your contention.
Yes. Carry on.
Now, therefore, my lord, that is my categorical case that I was not served with any notice. Now, my lord, you respect, my lord. The indoor development has no manner of application in our case. If your lordship kindly have the look into the judgment, what was the reference before the special bench, before the constitutional bench of the Supreme Court, issue pertinent to, my lord, the indoor development. Their question arose, my lord, indoor development, what has explained or clarified, overruling the, my lord, the ratio decided in the Pune municipality, subsection 2 of section 24, nothing more, nothing less. In my writ petition, I have not sought for any relief under subsection 2 of section 24. So a judgment should be relied upon based on the facts, given facts and circumstances of the case. That is the settled principle of law. Now, my lord, a judgment has been relied upon, an unreported judgment has been relied upon, Bholanath Kole. Kindly have a look at the that judgment. What was the issue that was before the learned judge? Here, my lord, if as I gathered from this judgment, that initially there was a challenge to the section 4 notification. Subsequently, this was withdrawn. And in this judgment, this was not the case of the petitioner like me, that award was not approved. This was not the case of the writ petitioner, as I find from the judgment, that petitioner was not served with any notice for payment, or etc., etc. Now, my lord, what was the issue? Kindly see, my lord. Here, my lord, I have said before your lordship that section 17 precondition is order from the appropriate government to the collector to invoke section 17. There was no such order for invocation of section. I shown to your lordship from the order itself. From the order sheet, your lordship will not find. Kindly have a look at the section 7, subsection 1 of section 17.
He can't go into the facts.
No, I am not going there. I am going to the law. Well, section 17 is not the fact, it is the law.
That is not the law, my lord.
Section 17 is the law.
On the previous, in the previous court, my
Can you
lord.
see?
My learned friend, my lord, after
Well, section 17 is a fact or law. Kindly see.
He wants to raise the facts. He has not any right to raise the facts. He must go into the, my lord, only law point, nothing else, my lord. For this cause, my lord, that judgment was not passed by that.
Okay, you confined to the point of law.
So for my little
Okay. I am court is accepting that the section 17 provision of section 17 not complied with in proper manner. Point of law formulated.
That was
Then, my lord,
discussed. Yes.
now, my lord, kindly see, my lord.
Yes.
This is the what was it sought for. In this case, part of the plot, due to the change of alignment, part of the plot was deacquisition, return to the landowners. Writ petitioner herein also sought for that after acquiring the property and declaration of award. Similarly, the case of the relied upon is a completely different case altogether in respect of my case. So, a slight different of a case, the facts of the case, ratio will not apply.
Yes.
And this is the ratio which has been decided in respect of another case, not in respect of the self-same proceedings. If this would have been settled in respect of the self-same proceedings, I would have been out of the court of law, this court. Now, my lord, kindly see. What was the argued? Kindly turn to, my lord, the page 4 of the judgment. Page 4.
Yes.
What is the
yes, distinguishable on fact. Okay. Thereafter.
So therefore, facts were completely different here in respect of my case. So therefore, my lord, this judgment has got no
manner of application. Yes.
Deciding the issue involved in my petition. Now, my lord. Yes. আবার তো ঝাঁপিয়ে পড়বে এক্ষুনি আমার বললে না ধরে পড়ুন না my lord, nowhere in the both the in my reply to my argument, nowhere it has been submitted before your lordship that award was approved.
Award what?
Award was approved. Award has never been approved, and that has been admitted by them because they have not said a word that on that particular day award has been approved.
That is a false submission. I submit for the lordship. Award was approved. And I have shown that part.
Now, my lord, if I am not wrong to say, if I am not wrong to say that I have said the false statement, now, my lord, what he has shown to your lordship.
My lord, that fact we can't say, my lord. Then, my lord, I may not.
What he is saying, I am replying to you. You cannot say me that you don't.
Oh, it is a question of fact. It is a question of fact. Okay.
Now, can you see, my lord,
Yes.
what he has said?
it is within the mind of the court. Don't worry.
My lord, what
Your
he has-
contention is that award was not approved and
what-
this contention.
What in support of his contention, what are the date he has relied upon? I like to show that thing only in my reply.
Yes. Yes.
Page 11. Page 11. My lord, the page 11. Page 11. It was shown to your lordship that award has been declared. Next, estimated such and accordingly sub-allotment work may kindly be made. Award has been declared. Then he shown to your lordship, page 15. Post award verification made by Sri such and such, encouraging such and such has been prepared and estimated award may kindly be approved. This part he was omitted.
Yes.
And this has been done intentionally and deliberately. This part was omitted. So, my lord, my respectful submission before your lordship will be this, that the record which has been produced before your lordship does not show that award was approved, which is a mandatory in nature. And in fact, my lord, in the law, there is no such provision that award can be declared as non-verified, particularly when I was admitted as a owner of the property and entitled to have the award, particularly when I was asked to appear before them and produce all the documents, and there is no denial to this and there is no dispute to this. And if there was any dispute, that matter ought to have been placed before the civil court for the purpose of adjudication. That has not been done. So therefore, my lord, respectful submission before your lordship, my lord, that not a single scrap of paper before your lordship has been annexed or shown to your lordship that the possession was taken over or any document pertinent to that, and no award has been declared. Therefore, my lord, the proceedings lapsed. And section 17(1) was never invoked. And in fact, their case is this: after declaration of award, possession was taken.
Yes. Hearing concluded, yeah. Learned advocate appearing for the respective parties have concluded their arguments. ठीक है, judgment is up.
না তুমি রাখো
Okay, it would be. I shall keep it. So give it. Yes.
এটা রেখে দেন
এটা এর সঙ্গে বেঁধে দেন।
ফোন নাম্বার রেখে আমাকে একটা ফোন করে দেবেন।
Yes. Next.
ভরত নেই এখানে বেঁধে দিন।
Well, as item 18, my lord, Mr. J.K. Mittal is appearing online from Delhi.
That
My lord,
matter.
yes. Well, that matter, this matter is
When
fixed
he
yesterday.
will be, who is your other side? Oh,
My lord, Tonay Chakraborty and Mr. Talimasul Siddiqui.
Yes, ma'am. No, sorry, my lord. May I start?
okay. When he will be able to come?
My lord, any date between 13th or 15th, subject to your lordships.
এদিকে এটা ওই
My lord, my arguments
My
was
lord, Mr.
over.
Mittal has joined. My lord.
Yes, it is the respondent has to argue. My lord, kindly see the order.
My lord, I can start. I didn't say, I can start.
Yes, my lord. Let the arguments be heard. Then,
okay, so you start.
वही है ना मतलब difficulty is when too many matters are fixed at 2 p.m. so you get मतलब may I just indicate the facts मतलब two issues have been challenged. One is the jurisdiction of the state.
Before my lord, before Mr. Chakraborty starts, I may kindly indicate there are 3 typographical errors in the last order of your lordship of 3rd of April. That may kindly be corrected. 3 repetitions, numbers are just typographical errors. My junior will hand over a copy indicating the corrections. In the first page of the order 2 and in the next page of the 1.
Oh. আমি লিখুন তো by reason of typographical আমি লিখুন stop আমি কেটে দিতে চাই the petitioner has pointed out that certain typographical error have been inadvertently crept into the order dated 3rd April 2025 ঠিক আছে আচ্ছা the number of the writ petition recorded in the second line of that order the number of the writ petition was recorded in the second line of that order as WPA 583671 in place of 5851 and the number of the writ petitioner recorded in the 5th line of paragraph 2 paragraph 1 okay paragraph 2 was erroneously recorded as 3678 in place of 3768 and similarly in the first line of page number 2 the number of the writ petitioner was recorded as 3678 in place of 3768 all correction are
May I just say one thing?
Merely typographical and ministerial in nature, and hence the error may be rectified as indicated in the foregoing paragraph. Offices may take necessary steps accordingly. Yes,
Grateful.
Mr. Anirban Rai is the learned government pleader. His name is coming. It should be top.
Okay, it would be
learned and my
in the next year. Anirban Rai
and my name is Tonoy Chakraborty, not Tonmoy. Everyone adds aim to it. Tonoy Chakraborty, but my lord kindly, my lord.
Oh, okay. Tonoy Chakraborty. ওই তন্ময়টা তন্ময় চক্রবর্তী the name of the learned advocate representing the state has been recorded as তন্ময় চক্রবর্তী in place of তন্ময় চক্রবর্তী. Office is directed to make necessary correction বলে করে দেবেন ঠিকঠাক ঠিক আছে থাক এটা আপনার কাছে রেখে দিন এই রেখে করে দেবেন whether it would be let all come and make their submission conclude the argument on that day
whatever I'll take about an hour, my lord.
1 hour
45 minutes, my lord. If I have to my lord, my learned senior friend has relied upon at least 10 to 12 judgments. But I have take some time to distinguish those things. I have to show those judgments. What my lord kindly fixes a name. Kindly, and I'll my lord kindly fixes a date. It will help us also. Why I'll tell you. I have asked the concerned officer to bring the original file because there was some confusion as regard to INS1 because there was certain allegation. I will ask my lord. I have the Xerox copies. But I want my lord to see the original file because there was some so fixes a date so that I can ask my officer to be present with the original file.
Okay, when you tell
subject to my learned senior friends convenience.
Well, the 13, if convenient, 13 is the Tuesday, or 15 is the Thursday.
13 book.
13.
15th. 15th.
Okay, 15th. 15th at 2 p.m. Okay.
At 2 p.m.
15th at 2 p.m.
MLA, kindly record my learned friend's submissions that he want to bring the original file to be produced next date of hearing.
Or production before the court.
I'll bring it, but there need not be any formal order. I'll bring it.
Okay. Court does not want to call for the record.
Yeah. My lord, since there is a challenge to the authorization.
For doing his job to assist the court, if he feels that he is to be consulted, then he will bring. Okay.
Grateful, my lord.
Grateful. Grateful.
Yes, my
Yes.
Hearing-
As a hard learned advocate appearing for the respective parties, this is the matter for further consideration on 15th May at 2 p.m.
Grateful, my.
Okay. Yes, next.
Well, item number 19, my lord, I am appearing for the respondent Fortress, my lord. My lordship, kindly remember in the last occasion, the first time the writ petitioner appeared, my lord, he prayed for to file a supplementary affidavit. Thereafter, my lord, the last day, my lord, the respondent number 13, my lord, this matter is went up to the Supreme Court, my lord. Everything was paid. Some amount was directed to be paid. They have not paid. We filed and we have disclosed the calculation to pay this amount. They did not pay. Thereafter, we took out an application being CAN 5. This application, your lordship, respondent number 13, the carrier agent, my lord, they prayed for time to file affidavit. Opposition replied, they did not file any opposition or reply. And the petitioner was directed to inform resolution professional officer. Either they will appear or the writ petitioner appear, because your lordship was the view, this the matter will be heard and your lordship will adjudicate. Whether they will pay or not, the payment may be suspended under the act or not. That is a different issue. Your lordship will adjudicate whether this amount will be payable or not. But they prayed for to file affidavits.
Well, it's an admitted position that I am out of time so far my affidavit is concerned. Now, what Mr. Jaina submitted right now, that proposition day is very important in this matter, my lord, because under this application, what he has asked.
Well, let them file. On last occasion, they have said, come with the issue. Now, whether they have any allegation or they admitted the claim.
My lord, under that circumstance, kindly extend my time for.
Yes, now they are asking this, I extend my time.
This is the respondent number 13.
Yes.
My lord, respondent is seeking an order before this court to an application against another respondent with the writ petition.
No. Both of them are. My prayer is the. He has
I
not seen my CAN application. Can you see my CAN application? Without seeing the record, my lord, something has been made submission before this court. This is not correct.
My lord, the admitted position is the writ petition.
CAN 5, your lordship, kindly see what is the prayer? CAN 5.
Oh, that matter, Allah.
Twice it was heard, your lordship observed. Either you file affidavit or your lordship will decide the matter.
So most probably they don't want to proceed with the case.
They don't want, because the matter went up to the Supreme Court, my lord. Time to time they have made the payment. The last month they have occupied my area, occupied land, my lord. They have not paid the balance area. I cannot charge in single penny access to my statutory rate. What the amount is payable as per the schedule of rate, that I have charged. Supreme Court has said you recalculate what the balance amount is due and payable. I have recalculated, computed the amount. I have informed them to pay this amount. They did not pay. So what is my remedy? I have come before your lordship with this application to pay this amount. And thereafter, now they are saying, I am not liable.
And against,
I will file affidavit. Last of
nobody else. The question is,
petitioner says, I am nobody else. The resolution professional officer, they will appear. They said we shall file an affidavit. Now said, they mean what is mean? We are not liable to pay. If that be the so, kindly.
Under what premises, my lord?
What is the submission, lordship, kindly appreciate.
My lord, if Mr. Jaina allowed me to submit, then I will submit.
No, you obviously will be allowed. I am making submission. Then you will allow. This is my application.
My lord, there's two things, my lord. First is there is a time was given to me to file my affidavit. My lord, I'm out of time. This is an admitted position. If your lord.
So don't file it.
My lord, I intend.
Court is bound to guarantee it.
That is not. Secondly, my lord. So
why? What is the ground? that you will get extension of time. Satisfy the court.
My lord, that is my submission, my lord. I cannot.
Submission, there must be some justification behind making
there
the
is no-
submission.
My lord, 4 years.
Unnecessary, go on giving it. When the port trust is claiming money from you, actually you took rent of certain portion of the port trust, you came.
My lord, that is where I joined.
You came. At that time, the name of the petitioner did not
He has made the
add.
payment. He has made the payment.
Aye.
I'll show you.
Did
He
not
has made the
did not surface. Then suddenly, when the port trust started, that you pay the rent.
My lord,
Then
that
you
is where- my-
then petitioner
My
came.
lord, deepest of respect, my lord.
Allah, such and such career is nothing. I am the owner. The issue went up to the
My lord,
Supreme Court.
kindly take paragraph 1 and 2 of the
No,
application.
no,
my
no,
lord,
no,
for
no,
one-
no. You are for the petitioner?
No, he's with me.
Oh.
Petitioner.
So there is a counter claim like thing. It cannot be dismissed for default.
Since the matter is sessioned before the Supreme Court has said that whatever the money you have paid,
Supreme Court has paid, you have released their goods.
release the goods
And they have left the pace also.
Yes.
Left the pace also, they have acquired.
Now the differential amount paid.
And now you will get some money.
So that Supreme Court said that has been remanded back to your lordship to adjudicate to that amount, whether this amount will be payable or not, that your lordship will decide only. Nothing remains in the rate.
Well, whereas my role is coming, I do not know. My lord, kindly come to paragraph 1 of their, paragraph 2 of their application, my lord.
The writ petition.
My lord, let me allow.
Application.
My lord, at the same point in time, my lord, he cannot went on objecting on the same thing when I ask for seek for time. My lord, either I will place my case or your lordship will be pleased to grant me time to file my opposition, my lord.
No, you place your case.
My lord, kindly come to paragraph 2 of the application, my lord. Now what the port trust is submitting, my lord.
Application as well as the writ petition also.
My lord, I'll submit, my lord. But I just want to show your lordship paragraph 2 and paragraph 3.
In opposition to the writ petition.
My lord,
How many amount you are now here?
My
How much amount you will get?
just my lord, my claim is 1 minute, my lord. In my
34 lakhs, Lord.
Whether port wants
22,079
lakhs.
39 lakhs. Along with the interest, that is statutory interest as per the schedule of.
Agents told me you are claiming that amount. From whom? From whom you are claiming that amount?
Both, my lord, you kindly say.
Cannot.
From both?
Both. I have the petition because, my lord, they are the agent of the petitioner, right? They have applied for the land.
On behalf of the principal.
Let me finish. On behalf of the that I'm saying, you are agent. You have applied for the before the port authority in respect of the land, and you have paid the rent time to time. Now the petitioner has gone to the resolution for professional officers. You are saying I am nowhere. Even if in terms of the High Court, in terms of the Supreme Court, they have made payment. I'll show you the document. Lordship, can you see?
Before your lordship take further cognizance of the submission of port, my lord, kindly take note what they have submitted, that I as an agent has approached the port authority to procure some land on this. My lord, now the question which boils down over here for adjudication, my lord, whether an agent can be liable for some act of the principal, and that too who is presently under a disclosed principal, my lord. And presently the principal is under a CIP proceeding against which a moratorium period is running. Now, my lord, IBC is a central act. I should not come in the way so far as their claim against the original petitioner is concerned. He is an agent and I am a principal, my lord. But
I'm an agent.
sorry, my lord. I'm an agent.
I'm recording it.
Lord, in that even, my lord, the submission of Mr. Jaina should be recorded first that I came in as an agent, my lord.
Have you got any statement of asset and liability? You produce. I can give you one week time. You produce no statement of asset and liability.
My lord,
which can be directed to be attached.
My lord, under what circumstances, my lord, kindly appreciate my lord, a respondent.
Court will justify. You can't question the court.
My lord,
under what circumstances I am bound to give answer?
I'm not a question, my lord.
Answer would be given in the order.
My lord, I am saying.
So say I am asking to myself.
My lord, asking to myself.
It is the etiquette of the court.
My lord,
I am not bound to give answer. What answer shall be given by the court That would be given in the order.
My lord, so far as the maintainability of this application is concerned, I'm joining issues over there, my lord. My lord, my stand in the original writ petition as a respondent, my lord. What they are trying to do, they are carving out a money claim.
Okay, petitioner, you try to find out. You now an interim resolution proceedings is going on against the petitioner. You try to find out their whereabouts, their property. You produce the same. You are at liberty to produce, and then the court shall pass the appropriate order. Huh?
Kindly pause. Both the petitioners and the agent also, both.
My lord, no, my lord. No,
Yes,
my lord,
yes,
so
they are
far
all
as the private
Achha,
respondent is concerned, I'm not at all liable, my lord.
On earlier occasion, it was submitted on behalf of the petitioner that corporate insolvency Yes.
My lord. My lord, I am for the Bhatpara Cooperative Society. Matter was heard at length, my lord.
Okay, yes.
That matter, my lord. Disciplinary proceeding, suspension without board, who will competent authority. Board is not functioning. Who is competent authority to suspend or to, my lord, file charge and, my lord, termination. According to my lord learned senior friend, that the without jurisdiction, the petitioner was suspended and ultimately terminated. According to me, the under section 36 of the Cooperative Society Act, when board is not functioning, my lord, administrator is the competent authority, my lord, to do the disciplinary proceeding. Here, criminal case is pending against the petitioner. Charge sheet submitted, and thereafter, my lord, grave charge, and thereafter, your lordship, kindly, this is the internal note sheet, the charge. Article of charge already, my lord, annexed, but this is internal note sheet. Kindly have a look into, in every page, administrator sign. That is Jitendra South, that time, my lord. Every page, in the bottom, my lord, signed by the administrator. And
so the disciplinary proceedings or every part of it was done with the approval of the administrator, as
yes, my lord,
as you are claiming.
my lord, and my lord, page 50 of the writ petition, my lord, whereas as per opinion from Deputy Register of Cooperative Society, Cooperative Directorate, 24 Porgonas, range about placing of suspension to Sagar Sengupta in view of the gravity of such offence, and thereafter on 10 March 2021, an approval from the administrator, district magistrate, not 24 Porgonas, page 50 of writ petition. Second paragraph from the top of the said bank and the chief executive officer are required to be placed with Sagar Sengupta under suspension during the inquiry into the matter. The approval from the administrator, who that time district magistrate was the administrator of that cooperative bank. And my lord, thereafter kindly come to page 56, memorandum of charges, my lord, third paragraph, the administrator and the page 56, my lord, that the administrator and the district magistrate, my lord, district magistrate did an administrator of Bhatpara Cooperative Society has resolved to hold a disciplinary inquiry following the procedure laid down in the appendix to chapter 5 under rule 106 of WBCS rule into the charges framed against him. Afterward, special officer also resolved the said matter on 7th December 2021, page 56. Thereafter, under the supervision, under the approval of the administrator, time to time, first time, my lord, district magistrate, thereafter, Mr. Sau, my lord, time to time, that was carried out by the CEO, Chief Executive Officer. Not only that, my lord, another point, my lord, taken by my learned senior pen, that inquiry, my lord, inquiry report not submitted to the petitioner. My lord, that is, my lord, my lord, consult with my client, my lord, that is not in the rule, 2011 rule 106. Nowhere it is stated that inquiry report, my lord, have to be, my lord, handed over to the delinquent. That was not, my lord, prescription in the prescribed rule of 2011. First of all, and secondly, he never approached before us for that inquiry report. And thirdly, my lord, I am submitting before your lordship that he admitted his guilt. I have already stated that he admitted his guilt in the, my lord, before the inquiry officer.
Yes, opposition inquiry officer.
Yes, opposition. Sorry, thank you. My lord, in my opposition, my lord, kindly come to page 16. I have already, my lord, read, my lord, just.
Yes, you stated admitted his guilt.
Yes, my lord. We have only 2 or 3 minutes. That observation, 1, paragraph 1, on behalf of the such and such cooperative bank, P. Gosal, CEO in charge, against the Sengupta being authorized by the then board of director, so-called notice was issued to Sri Sengupta of CEO in charge. Sri Sengupta replied to the notice. He gave the reply dated such and such, wherein he admitted his doings, but stuck to the point that he has done it under the instruction of the senior officer. My lord, it is the service ethic to respect and carry out order of the senior officer. This thought compels the Sengupta to do what he has done. Verbal instruction, senior officer, that's why I have done this. That is one type of guilty pleaded. Guilty plea, one type of verbal instruction. My lord, that is their reply written, page 16. This is my submission, my lord.
Yes. Anything in reply?
I don't only last submission I have elaborately made my submission. I have already completed my submission.
Yes, you have completed yours.
I have already referred all the judgment of what is foreign from my lord on last occasion that if the punishment passed, since the petitioner has already retired from on 30th November, will take retired benefit in terms of the law settled by the what was fallen from my lord, that whether if he is convicted, there is scope for to recover the amount. My lord, when this question comes, when until and unless there is a pecuniary loss suffered by the institution, the question of recovery does not arise. Until and unless in the charge sheet there was no allegation of suffering pecuniary loss, no allegation. In the FIR, no allegation. This is my first point. Second point, my lord knows very well, better than me.
A new submission made by my learned senior friend, my lord, pecuniary loss. It is not in the
my lord
first time.
My lord knows very well.
Court on that date asks that here quashing of the dismissal disciplinary proceedings would be result in your exoneration from all charges. Then the question will come to make payment of all service related benefits. But facts remains that one criminal case is going on against you. That if you ultimately held guilty and convicted, then what will be the right of the employer?
You will suffer imprisonment. There is no.
In respect of a convicted employee, an employer has a right him to dismiss from service.
Already dismissed during the service period.
I have understood. Yes, I have got his reply.
And regarding my lord, pecuniary loss, for that reason, anticipatory bail rejected by this honorable court. Page 13.
Ultimately,
I annexed.
That it was filed, still pending, nothing.
He is claiming another.
Criminal, my lord, monetary loss is there. Not only the petitioner, a branch of employee along with superior officer, my lord, monetary loss is there. For that fake loan, my lord, to the fake person. 11 criminal cases started. My lord, that time, I'm not saying the name. And he is one of the part. He may be, my lord, lower division clerk, but he is one of the accused.
No, he is a grade 2B officer. Posted establishes.
Then he is trying to say, even if he is convicted in the trial, the question of recovery will not come here, since there is no allegation of financial or pecuniary loss on the part of the employer due to any action taken by the employee. Here, no allegation of pecuniary loss. So, question of recovery of any amount from an employee who may be convicted later on cannot arise. It is his submission. Okay.
With due respect, I am submitting, my lord.
I am to give clarification and clarify the what other side is
only
to argue.
Only 1 minute.
Pecuniary loss is there. Kindly have a look into the section, charge sheet section 406. 420.
406.
My lord, yes, criminal breach of trust. Your
No,
lord.
no, oh, yeah, it's in criminal breach of trust.
Yeah,
Criminal breach of trust in respect of which one file?
not one file. Monitored, my lordship kindly.
What is the allegation here? I have just forgot.
The charge sheet, my lord, kindly.
What is the allegation? One line. What is the allegation?
Allegation is that he, in connivance with an officer, snatched some papers of the.
Oh, yes, yes.
Why?
Catch
Why he
something.
snatched?
This is
Why he snatched?
this is the only.
Done by chain, my lord. Circumstances. Why he snatched the peon book?
Okay.
For my lord.
Okay, ensure his conviction in the trial. Ensure his conviction in the trial.
I will suffer imprisonment till date.
Whether due to scratch of this record, whether you have suffered any pecuniary loss.
One of the part of criminal breach of trust for monetary loss of the Bhatpara Cooperative Society. Crores of the money involved in this matter. Not only this matter, 11 criminal case started.
Against
Not because all employees.
All right.
Chain, my lord. One chain, my lord.
Is very well known to every citizen of the West Bengal, every people of the West Bengal.
Your lordship passed the order in favor of the petition. I am not on that. But pecuniary loss is there.
Okay, okay, 14 to.
Pecuniary loss is there.
Yes. I am recording. That pecuniary
And the last
loss, it is your submission.
And the
Was
last
there.
one,
Yes.
I knows very well. Presumption of innocence.
And that's why anticipable rejected. Voluminous CD.
And presumption of innocence is the golden rule of criminal jurisprudence, which states that until and unless
Yes. Yeah.
is innocent, until and unless the charge is proved. Now, today, when the issue is before my lord for consideration, he is innocent. Apart from that, one judgment of the Honorable Supreme Court is there. Court is to resolve the issue agitated by the court.
My lord, kindly come to the charge sheet of criminal. The fact of the case conducted by the CID West Bengal. Kindly come.
Okay, 406 is there. Your charge sheet is not on record.
No, my lord.
Yes,
Criminal charge sheet.
Criminal case.
Criminal case record, FIR, charge sheet, everything I
On record. Okay. যে যা দিচ্ছে নিয়ে নেবে।
যা দেবেন নি।
Yes, give it. 406. Yes, breach of trust. Okay.
And my lord,
Next.
I have already concluded, my lord, sir, the golden rule. Till today, he is innocent. And
You have given your judgment.
And I've already all the judgment I have.
Okay. Hearing concluded.
On last occasion, Rup Singh Negi, my lord.
Rup Singh Negi, 2009 Supreme Court. Volume 2. 570.
Paragraph 14.
Administrator conducted the disciplinary proceeding. Time to time, administrator changed by the government of West Bengal. First time DM, there are another IS officer. Regarding, my lord, that jurisdiction point, my lord, there is no such lacuna. First and second, my lord, pecuniary loss, that in criminal case, my lord, simultaneous proceeding. Criminal case, disciplinary proceeding, no, my lord, simultaneous proceeding. Here, departmental proceeding, my lord, he has given opportunity to participate in the, my lord, proceeding, and he pleaded guilty. And so, my lord, this is a, my lord, I'm submitting before your lordship that
no scope to interfere. Yes, করে দিয়েছেন তো? হ্যাঁ? Conclude করে দিন, হ্যাঁ। Hearing concluded, judgment is yes.
Grateful, your lordship.
Next.
আমাদের নামগুলো দিয়ে দিস তো?
হ্যাঁ, এখন আরেকটা হবে ওদের আপগ্রেডেড, হ্যাঁ। 22, yes.
22, my lord. I am appearing on behalf of the petitioner, my lord.
A1 enterprise and another. What happened?
My lord,
it is 22.
Item number 22. Here?
I am for the petitioner.
Yes, 22.
Dilip Ganguly, my. No, my lord, A1 enterprise.
A1 enterprise.
No. Dilip Ganguly.
এইবার বলছি আমি ও হো সরি দিলীপ গাঙ্গুলি yes to release the increment including terminal benefits scale of pay sanction is leave of absence on medical ground instead of yes what happened
Well, the petitioner was appointed as a junior clerk on 1st July 1977, and thereafter his service was confirmed on 1st January 1978, and on 1st December 1980 he was promoted to the post of senior clerk cum cashier from junior clerk, and ultimately he retired on, my lord, retired on
31st May 2000.
31st May 2008. My lord, kindly. All pensionary benefits has been 18. All pensionary benefits had been given to the petitioner. Pension was given, and my lord, kindly see the impugned order first. Page 89.
Pension given.
Page 89, Annexer P9A.
Yes.
Operative portion, my lord, may I read? Please note that your monthly pension could not be credited on 1st December 2020 in your pension account, and it will be withheld till receipt of the documents, sanction letter from your unauthorized absence for a total period of 1,101 days in 65 occasions beyond 7th June 2023 at our end. Kindly listen, my lord. Page.
Yes, got it.
Page 85. Annexer P8. With reference to your letter dated 9th September 2018, enclosing copy of order serial number such and such dated at this may please be noted that retired benefits has been released in your favor by reference number such and such dated ato, and Bongio Gramin Vikas Bank such a dated copy of other letters and computation sheet is enclosed for your ready reference. But kindly next page. This is the entire matter will be cleared, my lord. The length of service, my lord, top of the copy, length of service 40 years, 10 months, 30 days. Period excluded from superannuation, if any, 3 years, 7 months, 9 days. That is 1,101 days excluded from my service career. Active service, next, my lord. Active service 37 years, 3 months. My unauthorized absence has been excluded by the authority and pension has been released. My client was getting pension 1.5 months, my lord. After that, the pension is being withheld by the concerned authority.
Yes.
Unauthorized absence has been deducted from my service careers.
Sir,
and after that, my lord, pension was released. PPO has been sanctioned. My client was getting monthly pension. Now, after my lord, 1st December 2023, pension has been stopped, has been withheld.
1st December
2020.
2020.
The pension has been stopped.
Okay, yes.
Withheld.
Then?
Therefore, my lord, I made several representation before the concern. They did not release the pension, my lord. My lord, page 86, everything will be clear, my lord.
Yes, thereafter, whether this court, any writ petition was filed earlier?
No, my lord, this for the retirement benefits, this writ petition is being filed. Earlier for promotion, but nothing has been done by the concerned bank. My lord, leave last.
Now, why you are, you have filed this writ petition?
For releasing of the pension.
Pension again stop?
Yes.
My lord, he is suppressing lots of things, my lord.
No, my lord.
2018, he filed a self and cause of protection.
No.
My lord, it is page 32, my lord. Page 32, my lord. They filed, my lord, as per the order of this court, my lord. Reasoned order has been passed by, my lord.
In 2018, what writ petition was filed?
Yes, ma'am.
Yes.
What
For
happened?
promotion, for promotion. Promotion has not been granted. Kindly see, my lord, after office order. After that petition, office order. Kindly page 32. Dated 9th April 2020. At that time, I was filed the writ petition for promotion. Promotion had not been granted to the petitioner. He had to retire in the post of clerk cum cashier. He was filed for the promotion of field officer. Kindly see the impugned order.
না না আপনিও চেঞ্জ করি আমিও চেঞ্জ এখন তো রেগুলেশন
So what wrong they have done?
My lord, the pension.
And what is your enforceable right?
Pension has been withheld.
Huh?
After releasing.
Forget about pension. If anyone does anything, he is sent to jail also in our judicial system.
Why, my lord?
Not in this.
An employee was getting.
Forget about the pension. Withholding the pension is not such a thing that you have to be taken aback or a surprise. You justify that your unauthorized absence. Admittedly, you are unauthorizedly absent for 1,101 days.
I had made several.
You
kindly see, my lord. I'm coming.
Allow the court to say, admittedly, as per the rule, 360 days can be adjusted.
My lord.
360 days can be adjusted.
Yes.
Now there is no provision to adjust the rest portion of leave.
Authority had adjusted my lord leave. I have made leave by making representation. They have regularized. Kindly see from page, my lord. Annexer P6, page 38. From time to time, I had made representation for leave. They have regularized. After retirement, they have sent the letter that the pension has been withheld. Kindly see the application, page 38. From time to time, I had made representation for leave before the concerned authority, and they have deducted the said unauthorized absence from my service career and released the pension. Page, my lord, from 38 to.
Yes, got it, got your point. Yes.
My lord, initially, when he is retired, my lord, there is no pension scheme in the bank, my lord. In 2018, the pension, as per the order of the apex court, my lord, the pension scheme introduced in the RRBs. My lord, thereafter, it is intimated to all the employers, ex-employers, to fill up the forms and deposit the document. When it is found that the petitioner was unauthorized absent for 1,100, admittedly, days, it was not regularized. And my lord, as per the provision of the 20B of the West Bengal, of the Bangio Government Vikas Employees Regulation, my lord, it is not possible to regularize that the delay. So, my lord, it is requested by the concerned bank authority to provide proper documents so that it can be somehow it can be adjusted, but it is not given any document provided by the petitioner. Even, my lord, their reply, they are saying, as my lord, it is we are retired before the employees regulation, so we are not within it. My lord, can you look into the
I have retired
prior to the
31st May
prior to the regulation. So we are not, they are saying that we are not, but they are taking the pension, applying for the pension in the pension regulation scheme. And now they are saying that it is not applicable to me. It is their reply, man.
The newly introduced pension scheme is applicable.
This is the first preliminary. There is no pension scheme in the bank. Many RRBs. In 2018, after the order of the apex court, RRB's pension scheme introduced by the RRBs. It is effective date was the 1st April 2018. Now it is effective date 1st April 1993. Now it is changed. When it is the first introduced in the RRBs, there is it is given 120 days to all the employees, the retired employees, to prayer for.
Okay, got it. But you answered his
query. As per 20B, my lord.
Yes, to you defend his contention, he is saying that you have allowed him to take that leave, you have adjusted the same, and you have
we are giving a details
from his service, and accordingly you have adjusted, and accordingly pension has been fixed.
My lord, the termination.
You have not initiated any disciplinary proceedings.
No,
nothing.
Termination.
That would be the why the condonation of the act.
But termination, that time the regulation is not there, man. When he was terminated from the service, that time the regulation.
When he was terminated.
Regulation is totally another thing. Regulation is a pension regulation.
Only pension, other benefits
and
is given.
It is
other benefits is admittedly given.
Oh, Mr. Sal, you are doing every day. And it is a control and disciplinary rules or regulation. It is totally thing. Another, if you find that any employee committed any misconduct, you have a right to take action according to the rule. And it is another thing. Now, Master Servant 11 is not there.
No, my lord. That's why, my lord, what the regulation says, my lord.
What the regulation says?
Regulation, I am annexing page.
That if he found that during his tenure of service, he committed certain misconduct, you can suddenly withhold the pension.
No, not suddenly, my lord. We are in our opposition. We have details to say, page 27 of our opposition. We are
okay. Page 27. Yes,
my lord. We also replied to them, my lord, that
no, it will not be. Why this your reply? You show the rule.
Rule is
empowering you to withhold and stop making payment of pension in respect of a person with whom you have no master servant relationship. as on date.
My lord, but my lord, the pension regulation is coming the 2018. We apply under the pension regulations.
Yes, only, yes.
The pension regulation scheme, my lord, not allowed him to take the either without authorization, my lord, the leave, unauthorized leave, my lord.
Okay, you show. Well, where is your pension regulation that you have the authority to look back any incident occurred during his service tenure?
Not with the rules, all rules, my lord. Come back with tomorrow, my lord. All rules with.
Okay, come back tomorrow.
Yes, my lord.
Yes. Under the order. Yes, yeah, I mean, yes. For the learned advocate appearing for the respective parties, stop, touch. Look back the incident occurred during his service tenure and take decision even including withholding the pension. ঠিক আছে? আর হবে? হ্যাঁ? হ্যাঁ? Yes, Mr. Bhattacharya, anything is there? Oh, to come tomorrow, আজকে যেখান থেকে সেখানে আপনি এক কাজ করবেন তো কোনটা আগে রিটার্নেবল দিচ্ছেন পরে আপগ্রেড দিচ্ছেন তাই তো ওকে